Announcement of Rajnama, MNC 856, 2008.
Lutas. 856 or Lutas.
MNC 860, 2008.
Under the circumstances and discussions made, this court is of the considered opinion that the learned tribunal fell into grave error in entertaining the appeal itself and subsequently granting the award. Accordingly, the impugned award dated so and so is set aside. MSc 856 is allowed. 860 is dismissed. Court also finds that the claimant's approach in making the present claim appears to be without any bona fide intent. Impugned award was passed without considering this crucial aspect. In the light of this circumstance, this court views the claimant's attempts to seek an enhancement of the award as audacious. A motor accident claims tribunal should not be approached for windfall or undue gain. Frivolous litigations, apart from being a gross misuse of the process of the court, is also adding to the pendency. This menace must be nipped in the bud to ensure that precious judicial time is preserved and utilized for effective dispensation of justice. Consequently, while dismissing the claimant's appeal, this court imposes a token cost of ₹5,000 to be paid to the Guwahati High Court Welfare Association. Statutory deposit is returned back.
Highly obliged, Lordship. Only one word, Lordship. Lordship might have written appeal. The tribunal was in grave.
We have not written appeal.
Highly obliged.
Yes.
Lordship, I would also like to mention item number 3, Lordship. Lordship, there is a that with the consent of other side, Lordship, that it come after vacations, Lordship.
18 madam.
True, Lordship, but someone has died. Respondent number 3 has died, so we are trying to find out the legal ad.
Okay.
That's why.
Respond number 3, there is no respond number 3.
Yes, Lordship.
Is there any respond number 3?
Yes.
Miss R.D. Madhukar.
They are till 4, Lordship.
Item number 3,
Yes, Lordship.
296.
Yes, Lordship.
Okay. Miss R.D. Madhumdar, learned counsel for the appellant, submits that during the pendency of the appeal, the respondent number 4 has passed away.
3, Lordship.
Respondent number 3 has passed away. And she accordingly prays for some time to obtain instructions, full stop, list after the summer vacations.
Highly obliged, sir.
May it trigger
Yes.
for a motion tomorrow. Civil
Okay.
litigation.
Lordship, item is 17, just for the day.
Item number
17. I have taken the
17.
consent of the other side, Mr. Rasif. 1 second.
it is for orders, Mr. Goswami.
Order, but Lordship, I think require some discussion. I do not have the copies with me.
Okay. On the prayer of Sri R. Goswami, learned counsel for the appellant, no applicant. Applicant.
I'm not.
There are 2 appeals.
Lordship, it's a year, Lordship. Rumabura is the appellant.
For you are the respondent then.
And the
For the applicant, you write applicant insurance company, prays for and is granted 3 weeks time
yes, Lord.
to obtain instructions. Mr. Sikdar has been informed?
Informed, I have taken it.
Okay.
May please, your Lordship, for motion day after tomorrow, Lordship.
What matter? What matter?
My injunction matter, Lordship, my injunction was due.
Fresh matter?
Yes, please.
Okay.
May it please, your Lordship. Lordship, I beg to mention item 11
Yes.
to be adjourned for the day, Lord. Today we have some difficulties, Lord. Let the matter come after vacation.
Okay. On a prayer made on behalf of the Mr. Mondal has been informed.
Yes, Lordship, we have tried to inform, but we could not get him.
Crying is not information, madam. Don't make a mention without informing. Don't do this mistake again. We'll impose costs like this. We have been repeating this matter every time. I will inform, try to inform. This will not do in this court. Yes,
Lordship, item number 24, your Lordship may not take up the matter.
yes, 24.
24.
Please before any other bench without me.
May I please? Lordship, I beg to mention for listing civil revision petition.
New matter?
New matter.
When?
Day after tomorrow.
Have you filed?
Yes, your Lord.
Tomorrow also you can try. No problem.
May I please? I pray for listing of I for withdrawal of that 15 lakh rupees they have imposed in a fee.
When?
Day after tomorrow.
Okay, Thursday. Okay.
May I please, my lord?
Right.
My lord, the insurance company has filed appeal, my lord, and 50% amount has been deposited. I have filed my lord IA for releasing. In the meantime, my lord, what happened, my lord, during pendence of the IA, I have filed another any additional affidavit. As because, my lord, the claimant, my lord, is suffering from kidney problem, both the kidney damage and.
Now tell us, what is your prayer
My
now?
lord, it may be listed for day after tomorrow.
DIA
IA, my
for
lord,
release.
for release.
Okay, we'll have this
Okay.
after tomorrow. Okay.
Well, your number, item number 5.
5 years.
So I took some time, my lord, after vacation, my lord. The opposite party is here.
Lordship may kindly fix a date because it is a whole matter, some urgency execution regarding. Your B. Sharma,
Yes, ma'am.
on the prayer of Sri B. Sharma, learned counsel for the respondent, matter is adjourned to be listed on. Yes, tell us.
Any date. Any date after.
On
vacation.
24th of July.
Deeply obliged.
May I please, Lordship? I beg to mention for listing to MFL, Lordship, on Friday, Lordship.
On fresh matter.
No, so 2024 matter, Lordship.
No, this is a motion. Is it a fresh matter? Admitted or not?
Not admitted, Lord.
Then
Last date of posting, Lordship, 29/5/2024.
what had happened then?
Then IA petition is there, Lordship, stay, IA for stay, Lord.
No, is the appeal admitted or not?
Not admitted, Lord.
Then we'll have it tomorrow while waiting for Friday.
Lordship.
Okay.
Your Lordship, a CRP has been listed today in the court number 17. Can it be taken today?
Is it urgent?
It is urgent. For stay.
What is the matter about?
Matter is for an order, challenging an order against section 30. The trial is pending.
Section 13 of?
30 of CPC. For additional evidence, they have admitted it at the stage when the argument has been heard.
Okay, inform the other side.
The first matter, so notice.
No, it's for motion?
Yes.
Okay, we'll have it. It will end. Item number?
Item number 8
8.
of court number 7.
My lord, I have similar prayer, my lord, in respect of item number 7 of.
Is it urgent?
Yes, my lord. Execution proceeding is going on, my lord.
Okay.
Oh, bless you.
Yeah, please, Lord. So, MSD appeal, Lord. It is for listing, Lord. For listing.
Fresh matter.
No, Lord. Pending matter, Lord.
Pending matter not this week, after the vacation.
After vacation, Lord. No.
Please, your Lordship. Lordship, I beg to mention item number 28, your Lordship. Lordship, I pray that the matter may be adjourned today, your Lordship. It may be fixed after vacation, your Lordship, on 23rd.
I am appearing for the respondent's lordship.
28.
23rd, your Lordship.
On a prayer made on behalf of the petitioner. List on?
23rd lordship.
A matter is adjourned to be listed on 23rd of July. And why 23rd? Is it for hearing?
Lordship,
Is
it
it
is
for hearing?
urgent
Okay, okay, hearing. 23rd.
There is an interim order that may be.
Interim order passed till to continue till the next date of listing.
Matter.
May I please, your Lordship? Lordship, I beg to mention item number 12.
12 years.
Lordship may kindly fix the matter after vacation.
Lordship, I appear for the respondent.
Yes. We have it after the vacation?
No objection at all.
Okay. On a prayer made on behalf of the appellant, matter is adjourned to be listed immediately after the summer vacation.
Okay.
Okay.
Obliged.
Your Lordship, item 24 of court number 7.
Yes.
Your Lordship, here we have filed one IA for injunction and the RSA is also pending. So kindly the matter may be taken up.
You have prayed for injunction?
Yes.
Is there any urgency?
Yes, Lordship. They have started construction.
Okay. Have you informed the other side?
I will inform.
You inform the other side, we'll have it. Because these only urgent matters are to be taken up of 17. Okay, we'll have it. Who is for the other side?
My senior will
Okay.
conduct it. Obliged.
Yes. My lord, the basic point which has been raised for adjudication is, my lord, whether a decree, my lord, which has been, my lord, given for execution can be executed in parts, because, my lord, a decree is always considered to be a composite decree, my lord. Lordship will find the impugned order at page 219, my lord.
You are the defendant.
My lord, I am the defendant. No, my lord, I am the plaintiff, my lord. He is the counterclaimant, my lord. Whose
Counterclaim has been
counterclaim was-
decreed.
Was allowed. It was dismissed,
Okay.
counterclaim was allowed,
Petitioner is the plaintiff
my lord.
and respondent is the defendant counterclaimant.
Counterclaimant. Suit was dismissed, my lord. Counterclaim was allowed.
Now, in the counterclaim, you are alleging that it contains several parts
Yes, my lord.
and one part is sought to be executed.
Yes, no, my lord. The counterclaim, my lord, in the counterclaim, they have sought a composite decree on the counterclaim as per the schedule given in the counterclaim. Now, what happened, my lord, when that decree was sought to be, my lord, executed, then they realized that the schedule originally given in the counterclaim was wrong. Then they sought for, my lord, to amend the schedule. The schedule was amended, my lord. Thereafter, again, my lord, when the process server went there and Nazir went there and reported that lands could not be identified, they again came to the court saying that no, that this schedule was wrong, the schedule ought to be like this. And ultimately, twice or thrice, the schedule was amended, and ultimately in the year 2022, my lord, the schedule was amended, my lord.
Yes.
While amending the schedule, my lord, and my lord, if your lordship, my lord, kindly sees, my lord, in the counterclaim, the counterclaim was made on the basis of a sale deed, my lord. The sale deed reflected the schedule of the land to be old, my lord, 31, Patta number.
Have you
old
filed
31,
any appeal against the decree?
Against the, my lord?
His decree?
No, my lord. That was not done somehow, my lord. We had come by way of a, my lord, revision earlier, my lord. Initially, this court, my lord, took consideration of that and stayed the order, but subsequently, that CRP was dismissed, my lord. And when that CRP was dismissed, my lord, liberty was given with a direction, my lord, that you execute the decree. Thereafter, my lord, on the basis of that order which was passed, my lord, a petition has been filed before the court below. And by the impugned order, the court said, my lord, to the Nazir, and go and you execute whatever is found. As for the rest of the portion of the decretal land, we will see later on, my lord. In my respectful submission, my lord, that cannot be done, my lord. That
Yes,
cannot be
any
fragmented.
any
my
case law?
lord. My
Any
lord.
case law?
Yes, my lord.
Yes.
My lord, there are some old cases, my lord. Very good. Welcome. Very good.
Please give the citation.
That is, my lord, very AIR 1935 Calcutta, my lord. 1935 Calcutta, page 118, my lord. In para short judgment, my lord. In
Yes.
para 2, section 39 of the CPC lays down that the court which passed a decree may or on the application of the decree holder send it for execution to another court. Evidently, the section contemplates that the entire decree and not a part of it is to be sent for execution to the other court or court. There is no provision in the Code of Civil Procedure under which a decree holder who has obtained a decree can divide a decree into several parts and execute them piecemeal in different court or in the same court.
But here the ratio is that a decree holder cannot divide the decree into several parts
My lord.
and execute them in the piecemeal in different courts or in the same court.
Yes.
It is not he has not chosen to divide the decree.
No, he had not chosen to divide the decree, but the learned court below the executing court
No,
says,
court
my lord,
on
because the power of the court, my lord, for fragmentation, my lord, if your lordship kindly turns to, my lord, section 52 of the CPC.
Sir, don't have your seat, we'll hear you. 52.
52, my lord.
Yes.
52.
Yes, please.
Section 52.
Yes.
Enforcement of decree against legal representative. Where a decree is passed against a party as the legal representative of a deceased person, and the decree is for the payment of money out of the property of the deceased, it may be executed by the attachment and sale of any such property. Where no such property remains in the possession of the judgment debtor, and he fails to satisfy the court that he has duly applied such property of the deceased as is proved to have come into his possession, the decree may be executed against the judgment debtor to the extent of the property in respect of which he has failed to satisfy
the court in the same manner as if the decree has been held against him personally. So only when it is for the recovery of money, my lord. And then, my lord, for the purpose of recovery of money, some land is thought to be attached or, my lord, executed. Then only, my lord, in the case, whatever is found, my lord, could be taken for the purpose of satisfaction.
No, is it a bar for other purpose?
My lord,
This is only clarified that when you are enforcing a decree against a legal
my
representative,
lord,
what procedurally adopt?
That
It will
is
have
my-
the same force.
my lord.
And if it's a money decree, then you can part. But where is the bar for other parts? Your main contention is
My
that
main contention is that, my lord, because now, my lord, lordship has to see, my lord, why I am telling the background of the case, my lord. My lord, if your lordship kindly comes to the sale deed, my lord. In that sale deed, my lord, that land which is purchased is given under a schedule, my lord.
Sir, Chaudhary, you know our limitation in revision.
No, my lord, we are not that much. I am just bringing it to
No
notice of the
revision.
court.
Had it been an appeal, we'd have gone whole hog.
No, I am not on that, my lord.
We are only at the prima facie
No, my lord.
satisfaction
Yes,
whether
yes,
the
my lord.
impugned order
I know, my
has
lord.
been passed within, as per jurisdiction, as per powers conferred by the court. That
Yes,
is
my
all.
lord.
Yes. Your
And
main
if-
contention is the degree has been sought to be fragmented and one part has been sought to be executed.
That is
So,
what,
case law, this Calcutta perhaps will not help you.
my lord.
Any other?
Page number 1. If your lordship kindly turns to page number 213, my lord. That is segment.
213.
213, my lord.
Yes, please.
At page 215, if your lordship kindly turns, my lord, to page 215 in the prayer,
215.
my lord. The decree holders have sought for fragmented, my lord, execution of the case. 215, my lord.
Just a minute. Two 115.
My lord.
Yes.
It is therefore prayed that your honor may be pleased to pass order and issue writ for execution of decree with specific direction to the civil Nazir, whatever land is found under DAG number 182 of PP number 43 within the boundary of the decreted land should be delivered to the decree holder and to submit report details regarding the remaining land, if any, cannot be delivered for the reason on the viewpoint of the ground reality. And this was the exact direction that was reflected, my lord, in the order which is impugned herein. My lord, that is why I am drawing your lordship's attention, my lord. My lord, throughout, my lord, there is a contradiction, my lord. That had not been pointed out and neither had been seen by the court, my lord.
Contradiction
lands,
where?
my lord, contradiction in respect to the lands which had actually been purchased, my lord. The lands were purchased, my lord, under Patta number 31. At page number 124, my lord.
Patta?
Patta number 31.
Okay.
Page number.
They claim, the defendant claim to have purchased this.
Yes, my lord.
Okay.
The predecessors of the defendant claim to have purchased this land. The vernacular portion at page 124,
Okay,
my lord.
but doesn't matter. Then
Patta number 31. If your lordship kindly comes to the, my lord, the schedule in the counter claim at page 110,
yes.
it is in respect of lands covered by Patta number 34. And there are
Patta 34 or 43?
34, my lord. They say that old Patta 34 is now converted to new 43. And in respect of 43, they seek execution, whereas the lands which they have purchased was in Patta number 31. And that is why, my lord, there are reports today which says, my lord, by the revenue officers, my lord, that these Patta number 34, that particular revenue village is non-existent, my lord. At page number 245, my lord.
But these matters are on the merits of the decree.
Merits
You
of-
challenge the decree.
My lord, that decree was challenged at some point of time. It was in a first appeal here before this honorable court. That first appeal was decreed. But these, my lord, things were not pointed out.
No, what,
at any
then
point. Today,
now
my lord,
in a
because that is why-
revision,
No, that is
can
why
we
the
go
lands, my
can we
lord,
go
could not-
back to
My
those
lord.
aspects?
My lord.
Or rather, can an executing court go behind the
We
decree?
cannot, my lord. That is why I am saying, my lord. If
So
the
whatever is
executing
there
court
in the
cannot
decree,
go-
whatever is there in the decree, they will execute.
Yes, my lord. So decree is Patta number 34, old Patta number 34, and new, my lord, this they have
43,
said, my lord.
43.
43. So, my lord, that old Patta number, my lord, 31, which they have purchased, does not connect to this new land. That is why
You
there are no
cannot
land.
raise this question. They had purchased 31, they had written 34 in the schedule. These are matters on merits.
Yes, I understand that. My lord, I have to point out to the
No,
government. I have
that
not
is
been
okay.
pointing
No,
out,
no,
my lord.
this perhaps would have been good point.
My lord,
If you challenge it on merits, the
My
decree
lord,
as such, the
my lord.
decree is not under challenge.
It's not under.
You are challenging a process adopted by the executing
Yes,
court
ma'am.
while executing the
Yes,
decree.
yes.
And we appreciate a submission that they has sought to fragment the decree and
Yes,
gone for. Okay,
Yes.
Mr. Dhar.
First of all, my learned senior friend has said that and talked about the amendment of the schedule of the decree. There was no amendment of the schedule of the decree. Your lordship, I will take your lordship to the schedule of my counterclaim. Because with your
Now, how do you react? Though we may not go into the respect, but how do you react? This
there
may
is
go to
no
the root.
amendment. There is no
No, no, this
amendment.
may go to the root. What Mr. Chaudhary is trying to
Yes,
urge,
they have not
that-
preferred any appeal against the decree.
that you had purchased the different
No, my
lot.
lord, no, my lord. We even this honorable court on
Yes.
earlier occasion, my lord, page 210.
Yes.
It starts from page 211.
What is 210?
This is the order dated 22nd of May 2024.
Of this court?
This court has very much clearly stated. This is a
Mm.
two-page order. This same petitioners have filed this under 227, another order of this execution proceeding.
Yes.
And paragraph 4 is my submission, ma'am. That has been recorded.
This was for what cause of action?
The earlier order that was stayed by your lordship.
No, no, what order?
This order was against the past in another mistake.
Yes, let us see the final
My lord,
directions.
Yes,
Taken to
may I
another-
just read? This is an application under 227 of the Constitution challenging the order dated 11/8/2023 passed
Okay.
by title application 3 of 2015, whereby the learned executing court, that is the learned court of the district of Dhemati, taking into account on the non-compliance of the various earlier orders passed to the circle officer, as well as the Lord Mandal had directed the Deputy Commissioner of Dhemati to look into the matter and take a necessary action. In addition to that, the SP Dhemaji was also asked to execute one section of armed force, including male and female, on payment of required cost by the decree holder as the site of the suit land. The circle officer Dhemaji Revenue Circle was also directed to depute Lord Mandal to be present and assist the civil Nazir for proper execution of the decree on the date fixed. Mr. Chaudhary, learned counsel appearing on behalf of the petitioner submitted that the learned executing court, while passing the order, had changed the schedule of the land, and as such the said order is not at all tenable. On the other hand, so the learned counsel for appearing on behalf of the decree holder, who is the respondent in the instant petition, submitted that the decree was being sought to be executed in respect of to the same schedule which have been decreed by the learned trial court. In that regard, during the course of hearing, the learned counsel has placed before this court the original decree which has been passed by the learned trial court, which has been affirmed by this court, and further the amended
Affirmed means affirmed where?
My lord, affirmed, Mr. My lord, this is the corrected one under 152. Earlier, the decree was passed, but the counterclaims schedule was not given.
No, no, affirmed by this court. Was there any appeal earlier? The language employed at 212.
I can understand, my lord. The trial court. That could be that court, trial court.
Or maybe affirmed by that court.
That
perhaps.
court.
Mr.
And
Chaudhary, there was no appeal, I think. Was there any appeal in this
No
court?
amendment. We
There
are
was
not
a-
seeking any
There was a
amendment.
regular first appeal in this court, my lord.
Okay.
Against the decree which was passed, my lord, and that was dismissed. Thereafter, the execution process started, my lord.
He
there
had,
was no
he
second
had
appeal.
preferred the appeal.
No, my lord, we had preferred the
You
appeal,
had
my lord.
preferred the appeal.
Yes, my lord. And my lord, there was, because, my lord,
No, the appeal was again dismissal of your suit or declaring the counterclaim.
My lord, I am not aware, my lord.
Okay.
At that point of time, perhaps it was against, my lord, this not dismissal of my suit, but against, my lord.
Counterclaim, decreeing of the counterclaim.
Decree of the counterclaim, it was against that, and it was dismissed. But the basic thing, if your lordship just please for 1 second, my lord, that schedule, my lord, that is why, my lord, this schedule, my lord, 2 or 3 times this schedule was amended. On the last occasion, if your lordship recollect, my lord, there was a draft decree which was given for, my lord, the rewriting of the court, my lord.
Wait, how can we recollect? We have never heard this matter.
My lord, initially at some point in the earlier stage, my lord, the first time, my lord, it came up before your lordship, there was a stay,
How
my
can you
lord.
remember one case?
181 page, lordship.
You can remember as a council. I remember as a council even now, what case I had done.
I understand, my lord.
But now sitting in this chair, I don't remember any case.
My lord.
Moment I rise, I forget everything. Delete button.
My lord. Only then the memory will remain clean, my lord.
Well, the
My lord,
correction was
if your
made by
lordship kindly sees, my lord, page 170. It starts from, my lord, page 168. And the petition to that is again in the earlier pages, my lord,
We may not
163.
be able to grant relief, Mr. Chaudhary.
They had even, my lord, prayed for changing the decree as a whole, my lord, because the schedule, my lord, was wrong throughout, my lord. And even now, my lord, the officers of the court, my lord, who go to, my lord, for the purpose of executing, they cannot reconcile the schedules, my lord. And that is how, my lord, time and again the schedules have been changed to, my lord, suit their requirements, my lord.
Wrong petition, my lord. I could show from the record.
Page
Okay.
number.
Heard.
At page 174,
Yes,
lordship to see even the circle officers report, my lord. That, my lord, it is.
That is why this honorable court has ordered
On 31/8/2019, my lord.
on last petition.
Heard. Sri G. Chaudhary, learned counsel for the petitioners who has presented this petition under Article 227 of the Constitution of India, challenging an order dated 10/6/2024 passed by the learned District Judge Dhemaji in title execution number 3 of 2015. Full stop. Also heard Sri A. Dhar, learned counsel for
Already
the
responded.
respondents. Full stop. Para. By the impugned order, comma, the learned district judge Dhemaji has directed the civil Nazir to deliver whatever land is found in Dag number 182 of PP number 43 within the boundary of the decretal land of the decree holder, and to submit report on the remaining lands, if any, which could not be delivered, along with the reasons. Full stop. Para. Sri Chaudhary, the learned counsel for the petitioners, has submitted that the impugned order suffers from perversity, as the learned executing court had failed to appreciate that there was a discrepancy in the description of the land. Full stop. He has specifically pointed out that while the land claimed to have been purchased by the defendants was stated to
By the predecessor of the defendant.
by the predecessor of the defendants. He was the defendant.
No, my lord. Their father,
Okay.
grandfather.
By the predecessor of the defendants was said to be under Patta number 31, comma, the schedule in the counterclaim was stated to be under Patta number 34, which was subsequently changed to a new Patta number 43. Full stop. He submits that the decree as such was an erroneous decree by which a different plot of land has been made part thereof. Full stop. Para. Sri Chaudhary has also urged that in any case, comma, a decree cannot be fragmented and part thereof can be put to execution. Full stop. He submits that that the execution of a decree has to be done as a whole and not in a piecemeal manner. Full stop. In this regard, comma, the learned counsel for the petitioner has relied upon a decision of the Honorable Calcutta High Court reported in AIR 1935, Calcutta 118, full stop. The learned counsel accordingly submits that there being error in exercise of jurisdiction by the executing court, comma, interference is liable to be made by this court under the supervisory powers of Article 227 of the Constitution of India. Full stop, para. Per contra, comma, Sri Dhar, the learned counsel for the respondents, has disputed the factual proposition advanced on behalf of the petitioners. Full stop. It is submitted that there was no discrepancy in the description of the suit land, which was correctly reflected in the decree. Full stop.
We have no objection if the decree is as a whole is executed.
Full stop. He, while submitting, he has also submitted that the decree as such was not interfered. But are you aware of any appeal file?
No.
No, are you aware that there was an appeal?
No, that I don't.
Also submits that as per his knowledge, comma, the decree had attained finality as there was no appeal preferred against the same. And therefore, at this stage, comma, the respondents cannot raise any issue on the correctness of a decree in an application filed under Article 227, that too against an order passed by the executing court while executing the decree. Full stop. The Sri Dhar has also drawn the attention of this court to an earlier proceeding before this court in CRPIO 314 of 2023, instituted by the present petitioners against an order dated 11/8/2023 of the executing court. Full stop. This court vide an order dated 22/5/2024 had held that no infirmity was found in the order dated 11/8/2023 of the learned executing court in title execution case number 3 of 2015, and accordingly the petition was dismissed. Full stop. While dismissing, comma, this court had made the following observations, paragraph 7, page 212. Full stop, para. The rival submissions have been duly considered. Full stop. The though Sri Chaudhary, the learned, though it is submitted on behalf of the petitioners that there was a discrepancy in the description of the land in question, qua the patta number, comma, this court is of the opinion that such discrepancy, comma, if any, has to be raised in an appropriate manner and not at the time of execution, and not by an application under Article 227 of the Constitution of India against an order of the executing court while executing the decree. Full stop. So far as the citation, on the other leg of the submission, that a decree cannot be fragmented, wherein reliance has been made on the decision of Kusum Kamini Devi Supra, this court is of the view that the context under which the observations were made on section 39 of the CPC was on a different aspect altogether, wherein decrees could be executed by another court. Full stop. Para. What this court has also noted that while dismissing the earlier TRP IO 314/2023 by this court by order dated 22/5/2024, the observation was made for executing the decree in accordance with law, in which the assistance of the Superintendent of Police Dhemaji was also to be taken. Full stop. The said order admittedly has not been put to further challenge. Full stop. This court is of the concerned opinion that the powers which are required to be exercised under Article 227 of the Constitution of India, being a supervisory power wherein this court is to examine the aspect whether the subordinate court had acted within its jurisdiction and is a limited power, the instant case does not appear to be such wherein such powers may be exercised. In the considered opinion of this court, the impugned order dated 10/6/2024 does not suffer from any jurisdictional errors or calls for interference by this court. Petition is accordingly dismissed.
Obliged. May I make a small prayer, ma'am? My lord, the next date is fixed by the trial court, my lord, on 4/7/2024 for the hearing on of the execution, my lord. Now, as your lordship is aware, my lord, under section 47 or under my lord order 21, rule 97 and 100, my lord, there is a provision for filing an appeal against an order, and that executing court is to take into consideration all the aspects of the matter which was just placed before your lordship, my lord. Till my lord, if 7 days or 10 days time be given to me so that my lord I can at least agitate that point. That my lands which are actually not.
No, you are not a third party. You are the judgment debtor.
Judgment debtor, my lord.
How will those provisions of law come into operation?
Because it is
Those are
between-
only
it is
for
between
persons
the
who are
parties to the-
dispossessed
My lord.
by a decree where they are not a party.
My lord. Between the parties also, my
No,
lord.
will not.
My lord.
Okay.
We can only try.
You have done your job.
We
We
can
have
only
done our
try.
job. Huh?
I'm
17
with you,
control. Motion আছে নি? এই বাকি motion নহয় নেকি? ঠিক আছে। There is one motion of court number 17. If the council is ready. Court number 17 নেকি?
I prefer time being first of all, my lord, item number 7, my lord.
No, code 17,
Item number 7.
8.
Item number এইটো কোনটো মাতিছে?
8.
Item number?
Item number 8.
Item number 7.
Sorry.
Mohammed Das.
Yes, my lord.
Yes.
For time being, my lord, it will be first of all.
What timing? You said urgent, we are taking
Yes,
this
my
out
lord,
of
my-
turn and you are
my-
seeking timing.
My lord.
Have it tomorrow then.
My lord, my tenure.
We are accommodating you out of turn. Only urgent matter you said. We have a whole list. You have seen our list. Still then you said urgent.
Then tomorrow, my lord.
Tomorrow. Okay. List for on the no, 3 MS Shaludar
Yes, ma'am.
submits there is urgency. Put stop. List for motion tomorrow.
Yes.
Item 8.
Yes, my lord. This revision petition has been filed against the order dated 25/24 passed by the learned civil judge Dhemaji in Miss case number 5/24, whereby
the learned court in exercise of the power under section 30 CPC allowed to adduce additional evidence, that too after advancement of the argument of defendant side. Hence, we have approached the honorable court about the legality and in exercise of the jurisdiction not vested by law.
Petitioner, how many petitioners are there?
Yes, at page 85.
One petitioner. One petitioner is the plaintiff.
Petitioner is the defendant.
Defendant.
Petitioner is defendant.
Suit for? Suit for?
Declaration of right.
Declaration of right title and interest and also recovery of possession. That was the
Right
plaintiff
title,
side.
interest and recovery of possession.
And we being defendant, we have filed a counter claim against that.
Okay, counterclaim.
Yes, yes, counter claim. we have.
And what is your counterclaim? What is the prayer in your counterclaim? Relief
Yes,
seeking?
we categorically stated that we are the owner of the land.
Now, what is the relief you are seeking in counterclaim?
Yes, sir, that declaration of the right title.
You're also seeking declaration.
Yes,
Okay. Then what happened?
What happened after due trial, argument was, date was fixed for argument and plaintiff side took argument for 2 or 3 days. Thereafter, defendant has took adjournment. On that day, the Lorded Court has imposed cost 2,000.
Okay.
Next day, the defendant advanced, court has allowed to advance our argument. On that time, the plaintiff side took another adjournment, which court has allowed. Thereafter, the plaintiff side has filed an application under section 30.
Under section?
30 of CPC.
Yes.
CPC. Which provides for exercise of the
Yes.
Section 30 says, subject to such condition and limitation as may be prescribed, the court may at any time either its own motion or on an application of any party. There are certain conditions and limitations. The Honorable Guwahati High Court has decided.
Please read this. Please read the entire section.
Yes, sir. Make such order as may be necessary or reasonable in all matter relating to the delivery and answering of injuries, the admission of document and fact and discovery, inspection, production, impounding, and return of document or other material object producible as evidence. Issue summons to persons whose attendance is required either to give evidence or to produce document or such other object as aforesaid. And number C, under section 3, order any fact to be proved by affidavit. And this was cited by the Honorable Guwahati High Court by Justice Khurana in his decision. The above quoted provision of law shows that power accessible under section 30 of PPC is subject to such conditions and limitation as may be prescribed. Moreover, subsection A of section 30 appears to be relatable to the provision of order 13 of PPC, which is for production, impounding, and return of document. Next question, sir. The provision of subsection B of section 30 of the code appears to be relatable to the provision of order 16 of the code, which is for summoning and attendance of witness. That is the contents of the Honorable Guwahati High Court. The petitioner side has not able to show that court has power to take recourse of the provision of section 30 of the code to overcome the requirement of leave of the court to admit a document in evidence as prescribed in subsection 3 of Rule 14 of Order 7 of CPC. In the present case, I find.
No, we are aware of that case. That case was decided that in that case, the conditions precedent were not able to be demonstrated. Now here, you kindly show us whether the application under section 30 filed by the plaintiffs were not meeting the preconditions necessary and laid down in section 30. Kindly show us from the order.
No, sir. There is no any statement in the pleading also.
Now let us read the order.
Order it is 8590.
Order is dated 25/2024.
Right.
Yes, please read.
What did it? Today is fixed for order the missed cases arising out of the petition number 57/24 dated 13/3/24 filed by the advocate petitioner for plaintiff on instruction of the plaintiff under section 30 A, B and order 16 rule 6 and 7 of the CPC, hearing of CPC, did with section 151 along with copy of Jamamandi praying to call for Jamamandi book relating to the suit plan from the circle officer Dhamaji, Revenue Circle Dhamaji, to produce and exhibit the same by Konthan Lakmandal. Peruse the case record at land. The petitioner has submitted that the plaintiff has submitted an old copy of Jamabandi of the suit plan instead of recent copy it due to oversight, and the same was unintentional on his part. He has further submitted that the said document is required to be called for to review the issue whether the suit plan is bid for non-tender of necessary party framed by this court. He has further submitted that the said document is highly required to be.
Yes, yes, okay, we have read. Can we know your name? You are Mr. Mazumdar?
Right. My lord.
Dr. Mazumdar?
Dr. P.C. Mazumdar.
Okay, heard. Dr. P.C. Mazumdar, learned counsel for the petitioner, who by means of this petition under Article 227 of the Constitution of India has put to challenge an order dated 25/2024 passed by the learned, please have your seat, passed by the learned civil judge, Junior Division number 1, Hemaji, full stop. The petitioner is the defendant in title suit.
16 of it.
Title suit number 16.
16, my lord. 16 of 20.
16 of 2020, wherein they had also filed a counterclaim. Full stop. It is submitted that at the argument stage, the respondents as the respondent as plaintiff had filed an application under section 30 of the Code of Civil Procedure. Full stop. It is submitted that without going into the aspect as to whether the conditions precedent have been met by the party approaching the court, the application has been allowed, which is not the purpose and intent of section 30 of the CPC. Full stop. Para. That notice be issued returnable on 26th of July 2024. Para. Let steps be taken for service of notice upon the sole respondent by registered post to AD, steps within 2 days. Para. Dr. Mazumdar, no? Learned counsel for the petitioner prays for an interim order. Para. Considering the facts and circumstances, this court, in the interest of justice, directs that till the next returnable date, further proceeding in title suit number 16 of 2020, pending before the learned civil judge, Junior Division number 1, Hemaji, shall remain suspended. Para. The interim order, however, would be reconsidered on the returnable date on appearance of the parties. কেভেটটো মই লিখাই দিম বাৰু কোন আছিল বা আদাৰ সাইডত এই ধৰ আছিল ন আচ্ছা এইটো কোনে লিখিছিল এইটো বিনয় এটা ৰিচাৰ্জ কৰি দিব কেভেট কেভেটখন আছে এটা ঠিক আছে সেপাৰেট অৰ্ডাৰটো মাৰি দিব দিব Item number?
Item number 2, if your lordship please to take it to part.
My lord, in the second appeal, my lord, my preliminary objection is this, my lord. The substantial question law framed, my lord, in this appeal is not involved in that.
Your lordship please to see the order dated.
Mr. Das, you want us to take Ila Borthakur first?
Okay. Second. Kitariko order. Kitariko order. Sorry?
Yes, please.
The question of law that was framed here is whether the suit of the plaintiff for declaration of right and interest, the suit was for declaration of right and interest
No,
and for recovery of position.
you are, the appellant is the?
It's the defendant. The defendant.
One appellant, more appellants.
More appellant.
Appellants were the defendants.
Dependent.
Suit for?
Suit for declaration of right and interest and for recovery of position.
Right, title, interest, and?
And recovery of position. Right and interest in respect of 1 bigha of land.
Okay. Recovery of position. Thereafter?
Thereafter, the trial court decreed the suit and the appellate court also decreed.
Your in concurrent findings.
Concurrent findings.
Suit decreed, appeal dismissed.
Appeal dismissed.
First appeal dismissed. Second appeal also dismissed.
No, second appeal yes. It is your lordship's hands. But this is a case for remand, I see. The question of law that was framed, I have not it here.
Yes, it was framed on 2/8/2013.
Whether the suit of the plaintiff.
2nd of August 2013, the substantial question of law was framed.
Yes.
Yes.
Whether the suit of the question of law was framed.
Yes.
In this way.
Whether the
suit of the plaintiff for declaration of right and interest in respect of 1 bigha of land can be decreed to the exclusion of other heirs of Ramananda in view of the pleadings in paragraph 7 of the plaint that Girijananda, the father of the plaintiff, out of 1 bigha purchased 2 kathas of land and 3 kathas of land, 3 kathas, 1 lectures of land was purchased for the father of Girijananda, namely Ramananda. 3 katha, 2 katha was purchased by the plaintiff number 1.
Right.
Predecessor of the plaintiff.
Other legal.
And 3 katha, 1 lecture was purchased by the father of Girijananda.
Ramananda was the grandfather.
Father.
Ramananda was the grandfather.
Grandfather of the
Ramananda. Then his son is Girijananda.
His son is Girijananda.
And Girijananda's son is the plaintiff.
Yes.
Plaintiff's name is Pranavananda.
Yes. Wife, son, and all.
Okay. Pranavananda and others. Okay. They are the legal heirs of Girijananda.
Yeah, Girijananda.
Okay. Then you say that Ramananda had other legal heirs.
Yes.
And out of this 1 bigha, 1 bigha consists of
3 katha plus 2 katha.
2 katha
plus 3 katha.
Plus 3 katha. 2 katha was purchased
by Girijananda.
Girijananda. Okay.
Yes.
So far as 2 katha is concerned, no problem.
No problem.
Girija. And 3 katha is by Ramananda.
Ramananda.
And you are the legal heirs of Ramananda.
Yes,
You are the legal heirs of Ramananda.
yes.
But can you exclude the plaintiffs also from the three kathas?
Pardon?
If suppose assuming we accept your case, 1 bigha, there are two parts,
Yes,
2 katha and 3 katha.
yes,
2 katha is purchased by Girijananda.
yes.
His legal heirs has got this 2
Yes.
katha. And so first, as assuming what you were saying will be accepted, 3 katha was purchased by the grandfather,
Yes, ma'am.
Ramananda. So grandfather's purchase 3 katha. The present Pranabananda and other plaintiffs will also have a part of the share.
Part of the share.
Okay.
But entire one
Not,
bigha,
not 3 katha immediate, not entire 3 katha.
not entire bigha. In that way, the plaintiff cannot get a decree for entire 1 bigha.
1 bigha. Okay.
That is the my case.
Okay.
Your Lordship, please to see the paragraph 7 of the plaint.
What
That
was
way-
the what was the finding of the learned courts?
Learned Courts Bureau has not given any finding. This is a new point raised for the first time in the appeal,
In second appeal.
second appeal. But the new point can be stayed, can be raised, my lord, in respect of the pleadings and the evidences on record. In view of the pleadings and the evidences on record.
A new substantial question of law can be framed as per law. It's a part of section 100. But whether a new point, which was not even the matter of adjudication by the courts, can you raise that point in a second appeal?
Yes, that can be raised.
In the victim statement,
If-
no
if-
confession days, then they are not a legal heir. They are not a legal heir.
Okay, we'll come. Nothing to be agitated, we'll come to you. We are trying to interact with Mr. Das. If Mr. Das 100, section 100,
Yes. If you sit down.
five proviso. Proviso to subsection
Nothing in
5.
the server shall be deemed to take.
No,
into
no,
a breach.
section 100, so proviso to 5,
Yes,
provided.
provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded and appeal on any other.
On any
subsection
other substantial questions of
not
law.
formulated by it, if it is satisfied that the case involves such question.
So this is only on a new substantial question of law which we can frame at the time of hearing. So that will not, may not include a point which was not even the matter of adjudication by the courts.
No, your lordship under subsection 1, if your lordship
Yes.
please to see it. An appeal shall lie to the High Court from every decree or order caused in appeal by any court subordinate to the High Court, if the High Court is satisfied that the case involves a substantial question of law.
Correct.
Now, if the court is satisfied, well, that a substantial question of law is involved in the case. May not be that it was agitated, may not be there is a finding in it. But if it appears from the records of the case, the such question can be raised and was framed by law at the time of admission of the appeal. Can it not be heard?
No, it can be heard if it can be inferred from the pleadings.
Yes.
But we are here to only to see the correctness, prima facie, of the findings arrived at by both the courts. We will not go back. If an issue was not specifically formulated, but there are pleadings and there are findings, we can go to the
Yes.
extent of correctness of the findings. But
Yes.
we, other than the correctness, we cannot again take the role of a first appellate court, again go back to the evidence.
My lord,
Our limitations are there.
that is correct. But my lord, a new point arising from the pleadings of the parties
In a second appeal,
in a second appeal can be taken.
Yes, kindly
Even in
show.
the Supreme Court.
Kindly
can
show.
take. My lord, 71. Good. More. AR 71 Supreme Court 2018. I am giving a copy to you.
please. AIR
71 Supreme Court
1971 Supreme Court
2018.
2018. Name?
নেম তো কি আছে সব মুখের কপিতে কোটো দিয়া
একটু তার photo।
So Kaushik, what is the name?
নেম ইজ
My lord, it's State of Rajasthan versus Rao Raja Kalyan Singh.
স্টেট অফ রাজস্থান ভার্সেস রাও রাজা কল্যাণ সিং।
Okay. Maintainability. Paragraph
3, 6 and 9. Yeah, 17 what? 17 what?
No, where is it in the second appeal?
3, 6 and 9. So, 6 says those issue is not very specific. Ultimately, it covers the plea taken by the respondent in paragraph 1 of his.
No, is it in the second appeal? Number 1. Number 2?
Yes.
Number 2, where do you get? Number 2, the point is of maintainability.
That is, of course.
It's a purely legal point.
This is also a legal point that whether he can get
It's a-
plaintiff can get a decree for the entire.
No, this point, all points are legal, but this will require a using of evidence that this land.
No, it will not require any evidence.
No. If you cannot say that the land, 3 katha of land was initially purchased by Ramananda, and you are the legal heirs, these are matters of evidence.
No, this is an evidence fact because in the paragraph 1 of 7 of the plain, he has stated it.
The plaintiff.
Yes, plaintiff itself.
What has he stated? Let us
Paragraph 7 of the plain,
page.
page কত? Page 11 better.
11.
11.
Yes. Yes.
And it has come out on evidence of the plaintiffs and the defendant.
1 bigha. Hospital 2 kathas
The only question is that his name was mutated. Girijanda's name was mutated in respect of 3 kathas of land.
But we haven't heard Mr. Sahiwala. What had fallen from him that you are not even legal heirs. That is what you are contending.
No, I am a legal heir of one of the daughters of Ramananda. He had only one son, 3 daughters. We are the legal heirs from one of the daughters. This has come out in evidence. In fact, in the pleadings in para 4, if your lordship please to see, page 10, para 4.
Based on para 4.
Our own nephew of late Girijananda purchased.
Was there a counterclaim?
No, there was no counterclaim.
So how do you assert your right?
Actually, the WS was filed contesting that they had taken on lease, but claimed adverse possession. That was negated. But it also came from the pleadings and the evidences on record, particularly PW 1-2 and DW 1-2, that the defendant were one of the legal heirs through one daughter of Ramananda.
So was there a claim, specific claim that as a legal heir, you have a right to the portion? That was not there. Not to talk about counterclaim, even in the written statement is not there.
Counterclaim is not.
But you say in paragraph 4 and paragraph 11.
Yes, paragraph 4 and
11 he has
7.
categorically stated that one portion belonged to Ramananda.
Yes.
It's a different matter that Girijananda's name was mutated.
Yes.
On the strength of it, he's seeing a declaration.
Yes.
And secondly, in paragraph 4, you say that your relationship has been accepted.
Yes.
And that's a different matter. The explanation was given as a permissive possessor.
Yes.
You were allowed to possess that land, and when he was in need of the land, he had asked you to vacate. That is the pleaded case. Okay.
But I want to place before your lordship another judgment of this honorable court.
Please, please.
79 AR 79 Guwahati. There. Page.
No, first in the case which
71.
had first cited 71.
71.
Where is it that it was a decision in a second appeal?
Good. So, no, it was not a second appeal.
There is no, you cannot decipher.
No.
It might have been, we do not know, but it's not net.
But the first appeal was before the High Court.
Maybe.
Paragraph T states.
Yes.
Paragraph T.
Yes.
Trial court party decreased the suit. It was
Yes.
held that the district
Yes.
court was not entitled to claim transfer. In appeal, the High Court dismissed the answer.
Okay, next decision.
What are photo? 79 Guwahati, AR 79 Guwahati, page 10. Paragraph 19 and 20. This is a second appeal.
Golaknath Kakoti.
Yes.
Paragraph
19 and 20. 18 and 19. 19 and 20. Judgment by B.N. Sharma, it should be J.N. Sharma.
No. It was B.N. Sharma only. Honorable J.N. Sharma was the counsel. 79, Justice J.N. Sharma was not a judge.
Yes.
B.N. Sharma, Bholanath Sharma.
B.N. Bholanath Sharma. Okay.
Okay. Please read.
Paragraph 19, Mr. Sharma, learned counsel for the appellant, challenged the decree of the lower appellate court on yet another ground, namely that the suit filed by the Registrar of Calcutta University is not maintainable. Mr. Sharma further submits that although this plea was not earlier taken on behalf of the appellant before any of the courts below, he is entitled to take this plea for the first time in the second appeal, as it is a legal plea. In support of his contention, he relied on the decision of the Supreme Court in state of Rajasthan, Pradhan Singh. This paragraph 20, that being the legal position, the appellant cannot be debarred from taking the plea.
Non-maintainability.
cited.
Non-maintainability.
Of course, it is on the ground of non-maintainability.
Non-maintainability.
আরো একটা question আছে। আরো একটা কি বার আছে? Supreme Court কি বার আছে? হ্যাঁ, Supreme Court। না, না, তোমাকে দিতে ছিল। 2014 or হ্যাঁ। What to do? Very good. My next case is 2014 2 SDC 269. 2014 2 SDC 269. This is party's name is Union of India and others versus
Vasavi.
Vasavi Cooperative Housing Society. Paragraph 15.
This is on the aspect that Jamamandi or records of right will not confer any title.
Yes.
These are settled law.
Otherwise also, the plaintiff is to prove his own case.
Own case.
And cannot
Depend on the weakness of the defendant.
weakness of the defendant. Here, something is there that
Yes.
paragraph 17 says the revenue record does not confer title.
Yes.
Here it was part of the the mutation record was placed by plaintiff show that mutation situation. Girijanand. I'm sorry, I forget sometimes.
No, doesn't matter. What is it?
The Girijanand's name was mutated in respect of three Katha.
Okay, Girijananda.
Girijananda. That was his claim, and because of that, he three Katha plus 2 Katha, own purchased land, it was declared in his name. He got the decree. In paragraph 17 of this judgment, it says that revenue records do not confer any title.
Yes, that's it. Okay.
No. And by the celebrated case of Santosh Hajari, 2001, 2001, volume 3, SCC 179.
Again on the same aspect.
No, it is something else. That justice is to be done. What paragraph? Paragraph 14. I more correct. Figure 14.
Paragraph?
Yes, 14.
Paragraph 14, madam.
Right. Huh?
Okay.
Okay.
Okay. What does it say? Santosh Hajari? Which paragraph?
No, Paragraph 14 below.
1-4.
1-4. This is about the question of law that is to be required to be framed.
Yes.
But the last line says, it will therefore depend on the facts and circumstances of each case, whether a question of law is a substantial one and involved in the case or not. The paramount overall consideration being the need for striking a judicious balance between the indispensable obligation to do justice at all stages and impelling necessity of avoiding prolongation of the life of any dispute. The first few lines, it says about the question of law that is to be framed. And what is the question of law in section 100? Definitely it is not of general importance. But the last line says, the paramount overall consideration being the need of striking a judicious balance between the indispensable obligation to do justice at all stages. Therefore, the question of law that has been to be framed, whether it requires to be framed in the facts and circumstances of the case. That takes in within its fold a new point also. That is my submission. And my lord, while all the courts below, both the courts below, while deciding the issues of right and interest of the plaintiff, had considered the pleadings of the parties and the evidences on record, which says, my lord, that the defendants are also the legal heirs of Ramananda through one daughter. They are the nephews. Okay. If you will also please to see what are the evidences part.
Okay.
Evidence part, my lord. Copy has nahi.
You want to read the evidence?
Well, only some portion.
Record. Dekha. Dekha. Record.
PW2.
Record. Record.
From the records, my lord, your lordship has taken. I have taken a copy. Copy has not. I have a copy has not.
You can read slowly. We are recording it. No problem.
PW2 is Vibhavananda. Vibhavananda. Paragraph 2. It says about that Ramananda purchased 3 kathas and Girijananda purchased 2 kathas. 3 kathas and 2 kathas. In cross-examination,
Yes.
yeah. PW2. In cross-examination, last part, it says the truth land consists of 1 bigha, 1 lecha, Connie, Nipen, Gannon, and Noren, they are 5, 6, 7, and 8, 8 and 9. Dependent number 5, 6, 8, and 9 are my cousin brothers, and they are the nephews of my father, that is Girijananda. Then DW2 and DW1. DW1 to the elaborate. Title. There are two evidences of dependent number 1, because in the title appeal also evidence was taken. Additional evidence was taken.
By the first appellate court.
Was the first appellate. প্রতিবাদী পক্ষ প্যারাগ্রাফ 2 প্রতিবাদী পক্ষগণের পূর্বাধিকারী গিরিজানন্দ ভট্টাচার্য এই শপথকারীর মামা শ্বশুর হয়। This is in chief. In paragraph 5, in one place it says, এই শপথকারিণী হাহু আই ভারতী দেবীর সহি জাল করি প্রদর্শক ঘ পৌর কর্তৃপক্ষের ওসরত দাখিল করি ভুল তথ্য দাগি রয়েছে। I am not on the other part. এই শপথকারিণীর হাহু আই ভারতী দেবী। হাহু আই is ভারতী দেবী. Bharati Devi is one of the daughters of Ramananda. And Mama Huri is Girijananda. These are the things. Therefore, the plaint and the pleadings and the evidences on record justify that there were other legal heirs also of Ramananda. Therefore, when you are claiming right interest in respect of the suit property, therefore you must have a clear title of the property, not based on any revenue record. This aspect was not gone into. Therefore, I would humbly submit that this matter relates to remand before the appellate court, so that the appellate court can look into this and give a finding whether he is entitled to the entire decree for the entire 1 bigha of land. That is the question.
The title having devolved upon him by inheritance, that was proved.
By inheritance, but a certain share, not the entire land.
No, that's a different context. Whether he becomes the absolute owner or one part, you also have a right. But can you go back to the aspect that whether he could able to prove his title in interest? Because it was not by any deed. His title has flowed to him by way of inheritance.
Yes.
That was
but
proved.
in respect of not the entire land.
And that is okay. That we have appreciated.
That is my issue, my lord.
Okay.
That is my, not the entire land.
No, if you are, since you are taking up the issue that it's the Jamabandi which was the basis of declaration of title. Jamabandi was not for declaration of title. Jamabandi is only to ascertain the possession.
Yes.
On the basis of Jamabandi title, it cannot be declared.
No, no.
Even
mutation cannot be declared.
He is seeking declaration on the basis, on the strength of inheriting the land from his predecessor.
Inheritance. But if there are other legal heirs,
whether it
he
could
can
have
claim,
to be shared. Yes, yes, that
is the whole question.
Yes. Yes, Mr. Sayola.
Hello there. What if stated case of the parties, my lord. If your lordship will see, my lord, the defendant case is based in para 17, 16, page 3 of the WS. That's the only case.
Page?
Page 16, para 16.
Yes, please read.
The answering defendant had to submit that let Nathan Chaudhary, who was the father of defendant number 8 and 9 and father-in-law of defendant number 1, let Nathan Chaudhary took total 1 bigha, 1 lecha on lease for 12 years from the patterer. Nathan Chaudhary expired before the term lease is over. Let Nathan Chaudhary and his elder brother, let Upen Chaudhary used to live and manage the Moja office therefrom, and let Nathan Chaudhary obtain holding and was paying municipal taxes. But later, Girinder Bhattaji fraudulently cancelled the holding of late Nathan Chaudhary. Nathan Chaudhary died in the year 1943. After his death, Bharati Devi, wife of Nathan Chaudhary, whose minor sons used to live in the Suitland till today, without any break. He submitted that Pani Chaudhary, the eldest son of Nathan Chaudhary and husband of defendant number 1, celebrated his marriage from the residential house over the Suitland in the month of 30th April 1977. And from the following day, let Pani Chaudhary was living in the Suitland with his family. Pani Chaudhary expired in the year 1998. After his death, his wife and children, the defendant number 2, 3, 4, are living there on the suit, constructing the houses there on 2008. The defendant number 8 got married on 27 March 1990 and defendant number 9 got married in the month of Fagun 1982. And since then, they have been living there on a suit with their family members. The dancing defendants are paying the land revenue of the Suitland. The signature of late Bharati, wife of late Nathan Chaudhary, sister of Girinder Chaudhary, was obtained fraudulently to cancel the holding of the house where defendant number 1 is living with still living with family members. The plaintiff does not disclose disposition, discontinuation of the position or any break in position of the defendant. Defendants have perfected their title to adverse position over the Suitland. This is their case, my lord. And that is a case decided by both the courts below. They found, my lord, that the adverse position has not been proved. They never, my lord, claim anything, my lord. A new case cannot be made out. Even 61 Supreme Court says, my lord, appellate courts could not make out a new case which was not treated by the party, my lord. AR 1961, Supreme Court 1097. There are many other cases also. This is a very old case.
Paragraph?
That's now one copy, my lord. My lord, that. Yeah. Another in envelope 2008-17 it should be 491. There are 10 11. 10 11.
Ten and 11.
10 11, my lord. Your lordship, I'm
Just a minute, please.
at page 490. High Court in this case, in Sophia Street, you also got
Please
to
read.
cut the delay hardship may ensue by delegating the plaintiff to one or more grounds of litigation has entered a judgment which violates the several fundamental rules of civil procedure. The rules listed are no amount of evidence can be looked into upon a plea which was never put forward in the plea. A question which did not arise from the pleading and which was not the subject matter of an issue cannot be decided by the court. Now, this is clear, man. A court cannot make out a case not clear. The court should confine its decision to the question raised in the pleading, nor can it grant relief which is not claimed and which does not flow from the facts and cause of action alleged in the claim. A factual issue cannot be raised and considered for the first time in second. 11. Paragraph civil procedure code is elaborate codification of the principle of natural justice to be applied to civil litigation. The provisions are so elaborate that many a time fulfillment of the procedural requirement of the code may itself contribute to delay. But anxiety to cut the delay and to further litigation should not be a ground to cloud the affair. My humble submission.
The one that page is missing.
Hello?
Second page is missing.
Oh, I'm sorry, I'm giving it.
Can you give your copy?
Next side, my lord, I think. Your lordship may just see. My single side, not there. I'm just giving the people. I'm sorry, my lord.
Just check, I did not find, just
Yes,
check.
yes, my lord, maybe, my lord. Yes. My lord, my peon has wrongly
That
done.
doesn't matter.
Yes.
Respondent.
That your lordship must compare. So they have admitted our title, my lord. They say plaintiff's title is extinguished by adverse cause. This is their case. Humble submission, my lord, the Supreme Question law, my lord, not involved in this case. And both the courts below have found, my lord, they failed to prove any adverse cause. There is no pleading at all for adverse cause, except writing the adverse.
Okay.
Well, in reply, I may say, my lord, that whatever my learned friend has cited is not applicable in this case, because it is not a new case. My lord, I have omitted to cite one case law, which appears 2010 2 STC 407. I am giving a copy to your lordship. 2010 2 STC 407, paragraph 17 and 18. Here in the second appeal, a new issue was raised, and that was the point of challenge before the Supreme Court. Paragraph 17, madam. As to the issue raised by the appellant that the High Court was not justified in permitting the respondent to raise a new plea for the first time in second appeal, we may at the outset note that would not find any substance in the contention raised by the learned counsel for the appellant. They contended that the High Court committed an error in considering the new ground of challenge without any plea or factual background, neither before the trial court nor the first appellate court. The new plea, which was already raised before the High Court for the first time, was that all assets and farm, including the land and buildings, shall be dealt with under Section 48 of the Act. That is with regard to the factual matters of that case. Paragraph 18. That apart, when the question of law is raised on the basis of the pleadings and evidence on record, which might not have been raised before the court below, it is difficult to hold that such a question of law cannot be permitted for the first time before the High Court. That was question was raised because it arose out of the pleadings and the evidences on the record. But the High Court had dismissed the plea, dismissed the. Perfect. Oh, perfect. Right. Well,
My lord, one thing I have to submit, my lord, that must come up from pleadings. No evidence which is beyond the pleadings can be looked into, my lord. Pleadings, my lord, your lordship, my lord, their pleadings is only a bad person, nothing more.
Okay. এটা দিদিম না কি করব? হুম? The instant appeal has been preferred under section 100 of the Code of Civil Procedure, challenging a judgment and decree dated 26/2/2013 passed by the learned district judge Nalbari in title appeal 8 of 2007. Full stop. The first appellate court vide the impugned judgment has affirmed the judgment and decree dated 30/3/2007 passed by the learned civil judge Nalbari. Not in title appeal, it should be title suit, I think. In title suit. Suit was 8 of, what was the suit number?
8 of 2000, sorry, my lord, it is 8 of 2005.
8 of.
Oh, sorry, sorry. I'm
In
sorry.
the cause title, you have written
No,
title
no, no.
appeal, Mr.
That is not
Kaushik.
there. That is not there. I'm just. My lord,
Title
it
suit,
is 8 of 2005.
title suit number 8 of 2005. No, in the cause title is written
Because
title
that they
appeal.
have wrongly mentioned as appeal.
Appeal. Full stop. The appellants were the defendants, and the suit was instituted for declaration of right, title, interest, and recovery of possession. Full stop. Para. No, para. This court wide order dated 2/8/2013 had framed the following substantial question of law. Order date 2/8, substantial question of law 2, very good. Para. I have heard 3. B.C. Das, learned senior counsel for the appellants assisted by Sri B. Kaushik. Full stop. I have also heard 3. G. N. Sahewala, learned senior counsel assisted by
Yep.
Sri Miss K. Bhattacharya for the respondents. Full stop. Para. Sri Das, the learned senior counsel, has submitted that the impugned judgment of the first appellate court, which has affirmed the judgment of the trial court, has not taken into consideration the materials which were discernible from the pleadings. Full stop. It is submitted that the suit land was suit property was a plot of land measuring 1 bigha, out of which 2 katha was purchased by the predecessor in interest by the predecessor in interest of the plaintiffs, and 3 katha was of was purchased by one Ramananda, who was the father of the predecessors in interest of the plaintiffs, full stop. It is submitted that the defendants are also the legal heirs of Ramananda, and therefore both the trial court and the first appellate court had erred in decreeing the entire suitland in favor of the plaintiffs without going into the aspect of the share of the defendants, at least on the portion of 3 katha which was purchased by Ramananda. Full stop. The Learned Senior Council has taken has drawn the attention of this court to the pleadings made in paragraph 11 of the plaint to contend that the aforesaid aspect was admitted by the plaintiff that Ramananda had owned 3 kathas of land, which is a part of the suitland. Full stop. The Senior Council has also submitted that though the Learned Trial Court as well as the First Appellate Court had decreed the suit, the aspect that the defendants were the legal heirs of Ramananda and therefore had a right at least over 3 kathas, which was a portion of the suitland. Line to qua. Have been aspect has been overlooked. Full stop. It is submitted that when a clear case is made out by the pleadings, it was incumbent upon the learned courts to formulate an issue and decide the same. Full stop. He submits that by the said inaction, the plaintiffs cannot be precluded, the appellants cannot be precluded from raising this point, which should clearly form one of the issues between the parties. Full stop. It is submitted that it is only when there is a dispute on certain factual position, an issue is required to be framed, and in the interest of justice, this court, being an appellate court, can go into that aspect. Full stop. The Senior Council has submitted that even otherwise, the issue being apparently available from the reading of the pleadings, the matter can be remanded back to either the First Appellate Court or to the First Appellate Court to decide the same on the aspect as to whether the decree could have been passed in spite of the fact that the defendants were the legal heirs of Ramananda. Full stop. The Learned Senior Council for the appellants has relied upon the following case laws. Case law
Para. Per contra, comma. Sri Sahiwala, the learned senior counsel for the respondents has submitted that issues are formulated based on the pleadings of the respective parties. Full stop. By drawing the attention of the court to the written statement, comma, more specifically, the pleadings made in paragraph 16 and 17 thereof, comma, the learned senior counsel has submitted that 16, not 17. 16 only, 17 is 16, 17, 9, 16 thereof. The learned senior counsel has submitted that the plea of defense of the defendants was of adverse possession. Full stop. It is submitted that the specific pleading was that the plaintiff had not disclosed dispossession or discontinuation of possession or any break of possession by the defendants, and they had perfected their title through adverse possession. Full stop. It is submitted that the plea of adverse possession was one of the specific issues which was formulated, namely issue number.
That directly, my lord, that is not the same, but it has been considered.
While criteria number 7 and 8 was that.
7 and 8, my lord, plaintiff said I take interest.
No, it says pleading of the defense of adverse possession was taken into account, and accordingly, issue numbers 7 and 8 were formulated and answered in favor of the plaintiffs and against the defendants. Full stop. Para, the senior counsel for the respondent has submitted that though it is correct that in the plaint, more particularly in paragraph 11 thereof.
Para 7.
7.
No, plaint 11.
7.
7.
Page 11.
Paragraph 7 thereof. Correct. 7 thereof. There is an admission of the relationship, comma. That admission has nothing to do with the claim of the plaintiff vis-a-vis the defense taken by the defendants in the written statement. Full stop. Para. The senior counsel for the respondent has submitted that a second appellate court cannot go into the aspect of a new case altogether, and there cannot be any reappreciation of evidence. Full stop. It is also submitted that this court, in exercise of jurisdiction under section 100, cannot go beyond the pleaded case of the parties. Full stop. He further submits that in fact no substantial question of law is involved in this appeal, and the appeal in this appeal which ought to be dismissed. Full stop. Para. In support of his submission, comma, the learned senior counsel for the respondent has relied upon the following decisions. 96 Para. In his reply, in his rejoinder, comma, Sri Das, the learned senior counsel has submitted that if the facts and circumstances require, comma, in the interest of justice, a new question of law can be raised and adjudicated even at a second appellate stage, full stop. In support, comma, he has cited the decision of the Honorable Supreme Court reported in so-and-so. Full stop. Para. The rival submissions have been duly considered and the materials before this court, including the LCR, have been carefully perused. Full stop. Para. The learned trial court had formulated 10 numbers of issues, and the issues which are relevant for the purpose of this appeal are issue numbers 7 and 8, which are extracted herein below. Full stop. Para. The primary contention of the advance on behalf of the appellants is that so far as a portion of the suit land is concerned, namely 3 katha, comma, they also claim to be the legal heirs of Ramananda and therefore entitled to a part thereof. Full stop. The aforesaid submission is also sought to be supported. No, the appellants has also sought the support of the pleadings made in paragraph 7 of the plaint, wherein the relationship has been admitted. Full stop. The claim made in this appeal is that the aforesaid aspect was not even gone into by both the courts, and therefore it is a fit case wherein remand may be made in the interest of justice. Full stop. The pleadings which are relied upon by the appellants, namely those made in paragraph 7 of the plaint, discloses that the plaintiffs had indeed admitted the relationship, admitted that the defendants are the relatives and legal heirs of Ramananda. Full stop. However, comma, it is to be seen whether such a statement would amount to an admission to the point involved in the lease. Full stop. The suit was filed, instituted for declaration of right, title and interest and recovery of possession. Full stop. It is specifically pleaded that while 2 katha of the suit land was purchased by the father Girijananda, which the plaintiffs has inherited, comma, the rest 3 katha was, though purchased by Ramananda, had devolved on Girijananda and thereafter upon the plaintiffs. Full stop. It is submitted that nowhere in the written statement any plea was taken by the defendants that they are entitled to a share of the shoot land on the basis of being relatives of Ramananda. Full stop. Rather, comma, as noted above in paragraph 16 of the written statement, there is a clear pleading clear claim that the defendant had taken the defense of adverse possession. Full stop. The the courts below had answered the aforesaid point through issue numbers 7 and 8, and had come to a finding that the defense projected by the defendants of adverse possession could not be proved, and therefore the suit was decreed in favor of the appellants. Full stop. In favor of the plaintiffs, plaintiffs. Full stop. Para. This court, in exercise of the powers conferred under section 100 of the Code of Civil Procedure, would not make a roving inquiry into the aspect of reappreciation of evidence, and it is only on availability of a substantial question of law which would be answered. Full stop. In the case of so and so, I don't pass the PG Board case to DD so and so. Para. Under the aforesaid settled principle, comma, let this court examine the application of the case laws presented by the parties. Full stop. The case of Rao Raja is, itself states that the question which was raised was purely a legal point of maintainability. Full stop. It is further not discernible as to whether such observation was made qua the exercise of powers under section 100 of the CPC. Full stop. In the case of Golaknath Kakoti, comma, the point was similarly on the aspect of maintainability, and that plea was allowed to be taken. Full stop. The case of Basabi Cooperative Supra is on the aspect that the plaintiff is to prove his own case and not depend on the weakness of the defendant, and further that a Jamabandi or any records of right would not confer any title. Full stop. There is absolutely no dispute with the aforesaid proposition. Full stop. However, in the instant case, comma, it is seen that it is not on the weakness of the defendant that the suit was projected or argued, but the pleaded case of the defendant that a defense of adverse possession was taken. Full stop. The issue of Jamabandi was only to demonstrate the aspect of possession, and the title had devolved upon the plaintiff by inheritance. Full stop. In the case of Muhammad Liaquat, Supra, the Honorable Supreme Court had made an observation that a new question of law can be raised in a second appeal. Full stop. However, in paragraph 18, comma, it has been clarified that the issue involved has to be one which is a pure question of law. Full stop. In the instant case, comma, the issues framed and answered are based on the rival pleadings, and the decision arrived at appears to be on the basis of the materials before the courts, including the evidence. Full stop. in the considered opinion of this court, comma, the present is not a fit case for exercising jurisdiction under section 100 of the CPC, full stop. Appeal is accordingly dismissed. The substantial question of law framed is answered in favor of the respondent and against the appellants. Send back the records. Okay.
And there is a revision, my lord, also.
Revision for?
Revision, my lord, against the order of the executive court, my lord. Here.
Who had filed?
Same case.
Who is the petitioner?
I am the petitioner.
Regarding?
I am the petitioner, because before the executive court, my lord, here what happened, my lord, in the schedule of the property, they will also see.
No, is there anything to be decided now in the revision?
Yes. No. Yes. Yes. My lord,
In
here
view-
what happened?
In view of the dismissal of the appeal?
No, this is of the appeal in spite of that, my lord.
You still have a problem in execution?
Yes, yes.
Okay, what is your problem?
Yes, that is. Negative for that.
Because this revision arises out of the stay order of this honorable court in second repeat.
Where is the impugned order?
Yes. Page 11, my lord. In the certificate of the order because I could direct it.
No. What I could do. I could do.
Like the remaining to Karaja plan. In view of the state order of the party, I could decree orders. File instant petition for execution of the recorded past.
No, we'll vacate this order of 6/12/2013 and ask the executing court to go ahead with the decree.
Yes.
Because the court has rightly observed, when his appeal was admitted and there was a stay, because his claim is on one portion of the suit land, and that was taken into consideration.
Yes.
Heard Sri G.N. Sahewala, Learned Senior Counsel, assisted by Ms. So-and-so, for the petitioner. Also heard Sri B.C. Das, Learned Senior Counsel, assisted by so-and-so, for the respondents. Full stop. The instant application is filed under Article 227 of the Constitution of India, challenging inter alia, and order dated 6/12/2013, passed by the learned civil judge Nalbari in title execution 3 of 2013, full stop. By the impugned order, comma, the execution petition was dismissed by taking into consideration an order dated 2/8/2013, passed by this court in Miss Case 1461 of 2013, arising out of RSA number so-and-so, connected, huh? Para? The aforesaid RSA number so-and-so has been dismissed today by this court. Full stop. This court is therefore of the opinion that there would be no impediment for the executing court to execute the decree in question in accordance with law. Full stop. The provision accordingly stands allowed, and the impugned order dated 6/12/2013, passed by the learned civil judge so-and-so in title execution so-and-so, is set aside.
Much.
মই কেছ লগ এটা দি দিম, এইখিনি তাতে দিব লাগিব।
Wait, please, Your Lordship.
Please.
Your Lordship, we have filed this appeal basically on the ground that the driver was holding a private driving license, Your Lordship, that was issued for 12 years.
and he was not authorized to
18
drive any
matter,
commercial
madam,
vehicle.
why did it has it come for admission? There was delay condemnation.
Yes, your lordship, delay has
Delay has
been
been
condoned.
condoned.
Yes, your
Okay.
lordship.
Come for admission first time.
Yes, your lordship, has come up for the first time.
P. Borthakur,
Yes, your lordship.
heard Ms. P. Borthakur, learned counsel for the appellant who has preferred this appeal under section 173 of the Motor Vehicles Act, challenging judgment and order dated so and so, huh? What are your grounds?
Lordship, basically, we have filed this appeal basically on the ground that the driver was holding a private driving license, your lordship, issued for 12 years, and he was not authorized to drive any commercial vehicle.
Policy conditions
Yes,
violation.
your lordship, there was
The
violation of
the
policy
learned
condition.
counsel has submitted that there was violation of the policy conditions with regard to the more in as much as the driver involved had a license for private vehicle,
Yes, yes.
whereas the vehicle involved was a commercial vehicle.
Commercial.
Put the para, admit, call for the records. Did they appear in the delay condemnation stage?
Lordship.
Did the other party appear in the
Yes,
delay
your lordship,
condemnation stage?
respondent number, in this case, your lordship, respondent number 1 has expired. And in his case, respondent number 4 was already a party. He was the son, your lordship,
No,
so
no.
he was implicated. And
In the
respondent,
delay condemnation stage, did they appear? Any counsel appear?
respondent number 2 has filed your wakalatama, but did not appear, your lordship.
So you have to take steps.
Yes, your lordship.
Steps, huh? Usual process within two days. List of the 6 weeks along with report on the receipt of records.
Lordship, there is an I for state.
How much amount?
Your lordship, we will, the award was 22 lakhs 4,000, your lordship, and we will deposit the entire amount, your lordship, subject to certain corrections, your lordship, regarding the conventional head part, your lordship. Under the conventional heads, 1,80,000 has been awarded,
No,
your lordship.
we'll not make deduction at this stage. You deposit 50%, let them come. Okay.
Yes, your
50% of state. Huh? Ki? Aye. Stake subject to deposit in the registry. Huh? Or the prayer for release of the amount by the claimant would be considered as and when such deposit is made. I still dispose of.
Obliged.
Alright. I maybe admit appeal. Appeal admit. I dispose of. We see a new counsel in the court, Mr. Chandok. No? We see a new counsel in the court.
Yeah.
You have some matter?
Yes.
Which one?
19.
19?
Yes.
Let us hope it reaches.
So,
Yes.
Lordship, I'm the applicant in this case. Yes.
For enhancement?
Enhancement.
Okay. How much has been granted?
Court has granted 7,37,000.
How much is your claim? How much is your claim, madam?
35 lakhs.
35 lakhs, yes. Oh, your name, madam?
AG Chaudhary.
Heard Miss A.G. Chaudhary, learned counsel for the appellant. Injury case,
Injury case, your lordship.
who has preferred this appeal under section 173 of the Motor Vehicles Act with regard to the judgment and so and so, full stop. The appellant has prayed for and is aggrieved by the adequacy of the award, full stop, para, admit, call for, Yes, Mr. Saikia?
Time for respondent number one. My name is not shown.
Okay, is this Saikia for respondent number one? You have got copy?
Yes, today.
Okay. Steps for service of notice upon the other respondents be taken by usual process. Steps within 2 days, okay. A list of the 6 weeks allowment report on LCR. So, name of Sri AJ Saikia, learned counsel for the respondent number one, be reflected in the court list. Okay.
My lord, this is an appeal filed by the insurance company on interest. Learned member calculate the interest on wrongly, lordship. Therefore, lordship, we have filed this appeal. They have claimed the interest of rupees 4,04,160, lord.
Just a minute, please.
And as per calculation, lordship, they are entitled for 90,312.66.
Just a minute, please.
Yes.
I go to this. I go to the action. Who is there? I go filter. I think there is some problem here. Put ki mari se to. Put it to. This is not your case. Yeah, it would really good to it. It would double easily. Q is it? AJ Chaudhary de matter puri le.
Item number 7, MSC appeal number 248 of 2020. Lordship, this is award, we have filed this appeal, Lordship, mainly on wrong calculation of interest purpose. Award was passed and we have satisfied the award, Lordship. Against it, the claimant filed an application and that this amount of rupees 4,04,160 they are required to get. So accordingly, we have filed an objection to that and learned member directed us to pay the interest, which is not tenable in law, Lordship, because interest is calculated at the compound rate of interest, Lordship. Yes, Lord. Yes, Lordship. 9,52,000. Lordship.
You are aggrieved by the order
Yes, Lord.
passed. Okay.
Lordship.
We'll admit this. You'll be appearing for the claimant. Heard Miss M. Chaudhary, learned counsel for the appellant, who are you required to file an appeal?
Lordship, because we have filed and reviewed their Lordship, that was dismissed.
Thereafter,
Thereafter, we filed an appeal along with challenging both the orders.
initial order also.
Yes.
Okay.
We are not on main quantum Lordship, we are on interest calculation of it.
Will appeal lie?
Because Lordship review that was not our, is not entertained, Lord. That was this.
The appeal
Along with the-
under 173, what is the language employed? As some Hericom motor vehicle section.
Motor Vehicles Act. It is only against an award. We don't
Award
think-
is also interest part is there, Lordship, along with the,
No, see, interest was enhanced in an application filed by them. You are aggrieved, you file a review dismissed.
Lordship.
Then where is the provision of appeal? I think you have to either file 227 or 27 is the only remedy, I think. Wanted to check whether it's against any award or any order. Order is not written here. It's against an award, has to be against an award.
against the- we have challenged both, Lordship.
No,
Award-
initial award, you have said that you are not aggrieved.
No.
You had honored, but only on the
Yes,
on the aspect of interest.
Yes.
They had filed an application for enhancement. It was done.
Not enhancement, Lordship, because they have given 6+ interest, but while calculating the interest, we have given the entire awarded amount, including the interest, 6% as simple interest, Lordship. But they have calculated, claimant has filed an application that award,
is it, yeah.
total awarded amount, that is including
Understood.
6%.
They had filed an application for, according to them, the interest was not properly calculated.
Properly, they have not given.
And that
proper-
plea has been accepted by the tribunal.
Yes, Lordship,
You
without
had-
without considering our point, Lordship.
Exactly. You had gone for review dismissed.
Yes, Lord.
Now, where is the appeal?
Is the entire award, Lordship.
Entire award is not under challenge. It is only on the aspect how
Quantum
you,
plus interest,
how you
Lordship.
calculate the interest. You said that you have satisfied the award otherwise.
Yes, Lordship.
What have you challenged here? Which order?
This is, Lordship, we have challenged this award judgment. And this judgment was passed this page, Lordship will find.
Let us see your cost title. Appeal under against
This
the
is a-
order.
yes.
No, it's against the order 11/12 and order dated 10/12/21 review, not against the award.
Then Lordship, I.
You take instructions.
Lordship, can you allow something?
We can convert this appeal can be converted into a revision because no issue is that. I have some instructions, okay?
Sure.
On the prayer of very good. Indication. Do this appeal has been preferred under section 173 of the Motor Vehicles Act, comma, the same is against an order dated 11/2/2017 passed by the and a subsequent order dated 10/12/2021 passed by the learned M.A.C.T. Tinsukia in MSC case number 76 of 2001, full stop, by the initial order dated 11/12/2017, comma, the tribunal has accepted the plea of the claimants towards which they had raised on the aspect of calculating interest, and by the subsequent order dated 10/12/2021, comma, the review petition filed by the claimant filed by the appellant insurance company has been rejected, full stop. Whether an appeal will lie under section 173 of the Motor Vehicles Act would be an issue, full stop. Para. Ms. Chaudhary, the learned counsel, accordingly prays for and is granted a week's time to obtain instructions.
Lordship.
We'll come
Supply.
after the vacation, let's see.
Lordship, must apply.
Please try to get some case laws. If case laws are there, otherwise we may convert it.
Must apply.
Lordship,
Yes.
Lordship, in this accident, 3 vehicles were involved, Lordship, and search sheet was filed against other 2 vehicles. But we are held liable to pay 50% of the awarded amount, and other vehicle is also given. But our vehicle was not offending as per search.
How much amount?
7,91,000.
That case.
Yes, sir. We are challenging our 50% liability. Sir.
50% has been
50%
settled
has
upon
been
you.
settled with us, Lordship. But
Yes, you are for the claimant.
For the claim.
Have you received any amount? Till now, nothing.
No, no.
Have you gone for
Copy-
execution?
Copy of memo. Okay.
Oh?
Copy of memo.
No, that's not the question. Have you got any amount till now? Have you gone for execution? No.
I'm appearing on behalf of the
Oh?
Barua.
No, that is okay. You should have the instructions whether you have got. See what. Have you understood what is their challenge? You have not understood. What have you understood? Tell us. No, you don't need to go to a senior. You have heard what the senior brother has said, has submitted. What has he submitted?
As for my instruction from my senior,
You leave aside the instructions. What have you understood from his submission? It's nothing to get nervous. He has said something. Have you understood something? Anything?
as per my instruction from my senior,
Yes.
lordship, I have the submission to direct to deposit 50% of their check. 50% of it.
That is what we are asking. Have you got anything till now?
No,
Even if you direct 50%, it will be 50% of 50%. So ultimately it will be 25%.
50% of their share. Their share is 25%.
You know about that. How many vehicles were there? You don't know. This is so difficult to study the brief. How many pages brief? Young counsel find it difficult to study a brief.
I go to file.
You should grab the opportunity, got the file, read it. At least have a cursory glance what is there. Know how to read a file, not the entire file. Read the impugned order, read the grounds of appeal. Okay, but if you deposit, it will be only 50% of your share. They can execute for the others.
Yes.
Okay. Heard 3 AJ Saikia, Learned Counsel. For the appellant who has preferred the appeal under section 173 of the Motor Vehicles Act against the judgment and award dated so and so, huh? It is submitted that 3 vehicles were involved and charge sheet has been filed against 2 other vehicles. And in spite of the fact that the vehicle of which the appellant is the insurer was not the offending vehicle, 50% of the award has been settled upon the appellant insurance company. Full stop. Para. Admit. Call for the LCR. Mr. Borua will be appearing.
For respondent 1, my lord, and we have not received any copy.
3 B. Borua, Learned Counsel, has entered appearance and accepted notice on behalf of the respondent 1, claimant. Let extra copy. And Mr. Bhatta, semicolon 3 KK 4. P. Bhattakur, Miss P. Bhattakur, Learned Counsel for respondent 4, and KK Bhatta for respondent 8. Let extra copies. Okay. Let steps be taken for service of notice upon the respondent 2, 3, 5, and 6, 7 be taken by usual process, steps within 2 days. List after 6 for service report. Service report as well as report on LCR. Heard. Three ages Aikya, Learned Council, who by means of this application has prayed for stay of the impugned judgment and awarded it so and so, passed by so and so, in so and so. Full stop. It is submitted that the vehicle of which the applicant was the insurer was not the offending vehicle. And in spite of that, 50% of the liability has been saddled with the applicant, full stop para. The connected appeal has been admitted today, full stop para. Considering the above, pending disposal of the appeal, the part of the award by which 50% has been saddled with the applicant shall remain suspended, subject to deposit of 50% of the share settled on the applicant within the registry of this court, full stop. The respondent number 1 claimant would be at liberty to pray for release of the amount as and when it is deposited. Highest can disposed of.
May I please, your lordship? So this is an appeal, lordship, on the point of negligence, lordship.
Oh, that was it, no? On the point of
Negligence, lordship.
Court number 27, I have requested to take up this matter.
27, court number 17.
Court number 17, Lordship. The respondent may left the court, so may be taken tomorrow or day after, any day.
Was it mentioned?
Yes, Lordship.
Who had mentioned?
In the morning, a request was made by my junior.
Okay. 24. Orders? Why
Orders.
urgency?
Injunction matter, Lord. IA was filed. for
Okay, have it day after tomorrow or tomorrow? Day after tomorrow. I do like it, huh? Miss R. Chaudhary, Learned Counsel for the
Lordship, appellate.
applicant appellant.
Applicant.
Applicant appellant submits that there is urgency. Full stop para. List day after tomorrow.
Lordship, I'll inform. Obliged, Lord.
Was the request made on your behalf in the morning? Okay.
Yes.
May I please, your lordship? Lordship, ground of challenge is the finding of negligence, lordship. Because, my lord, the case of, this is the case of head-on collision, my lord. So we are challenging the finding of negligence because the entire negligence has been settled on us, my lord.
No contributory factor?
Yes, my lord.
There is another vehicle?
Yes.
Okay. Heard Sri T. Kolita, Learned Counsel for the appellant who by means of this appeal referred under Section 173 of the Motor Vehicles Act has put to challenge a judgment and order that is so and so passed by so and so in so and so. It is submitted that while 2 vehicles were involved, the aspect of contributory negligence has been overlooked and the entire liability has been saddled with the appellant. First para, admit, call for the records. Mr. Das for?
Respondent number 1, claimant.
3, D. Das, Learned Counsel, appears and accepts notice on behalf of the respondent number 1. You have been served with a copy?
Yes, Lord.
let steps be taken for service of notice upon the respondables
2 and 3.
2 and 3. Yes, you have not made the other insurance company a respondent.
Lordship, that vehicle was written by the deceased himself. That is why we are challenging the continuing release, because it came out during cross-examination that.
But you should make the insurance company a party. It's up to them to deny whether they'll be liable or not. That's a different matter.
But they were not made party before the tribunal also.
They did not make them party.
No. Because that vehicle was written by the deceased himself. So it became the case of head-on collision that came out during cross-examination. Not a case of composite negligence.
Raised by usual process. Steps within 2 days. IA for stay. How much is the amount?
8,70,000.
That case.
That case.
That case, 50%. 50%. Asana, I go 50%. Our last order, the prayer for release of the amount would be considered as and when the amount is deposited.
Maybe given liberty to withdraw.
We will consider. Let them deposit. You make a prayer.
Much.
I dispose of.
Yes. In this case, we have challenged the quantum of the judgment on order dated 22/8/2022.
You're the owner.
Yes, no, I'm the claimant.
Oh, you're challenging, you're praying for enhancement.
Yes, announcement.
Your name?
Yes, sir.
S. Roy, learned counsel for the appellant, who by means of this appeal preferred under section has heard three S. Roy, learned counsel, who has preferred this appeal under section 173 of the Motor Vehicles Act, praying for enhancement of the award given by judgment and order dated so-and-so, past and so-and-so, what grounds?
They have taken only 5,000 income actually of the.
What is your monthly income?
14,000. We have submitted the GP certificate. That was
And what else? What else?
Pardon?
Income is one ground. Any other grounds?
No, this is only the.
It is submitted that the principal ground for enhancement is that the aspect of monthly income has been wrongly taken as rupees 5,000.
5,000.
Whereas, there were materials on record, including a certificate by the Gaon Panchayat to demonstrate that the deceased, that case was earning, was receiving a monthly remuneration of rupees 14,000.
14,000.
Okay, for the para. Admit. Call for the records. Step by usual process within 2 days.
Not a
Last one, list after 6 weeks along with service report and report on receipt of records. Yes, madam.
Lordship, in the morning I have asked.
Yes.
Date for the.
Lordship, I have no objection.
When do you want?
Lordship, after vacation.
Okay.
Any date of.
On a prayer made on behalf of the appellant, list after the vacation. What's up? 3D Mondal is present for the
Respondent number 1.
Respondent number 1. Okay. Your name is shown? Yes. Okay.
Apply.
Yes, orders 13, item 13.
Please seize your lordship. Your lordship, in this case, service is completed upon the respondent.
LCR not received.
No, your lordship, LCR has not been received.
while admitting this appeal, wide order dated
Appeal was
17/6/2013, comma, records were called for. Full stop. However, till now, the records have not been received in spite of reminders by subsequent orders, full stop. Registry to issue urgent requisition for calling for the records, calling for the LCR. As it appears that the last reminder was issued on 13/9/2022. Full stop. List immediately on receipt of the records.
Obliged, Your
Yes. Item 14. AC Kolita. Mr. Saikia, is it Saikia, respondent? Mr. Saikia, respondent, come. What is this? Item 14.
I am for respondent.
No, we
but
know.
So far, my knowledge goes to Mr. AC Kulita has expired.
Okay.
It is
sorry.
not approved.
Okay. None appears for the appellant on call. Full stop. 3 Aegis Saikia, Learned Counsel for the respondent insurance company.
Yes, Doctor.
Respondent insurance company has however informed that as per his has apprised that as per his information, comma, Sri AC Kolita, the learned counsel for the appellant, has passed away. Who AC Kolita?
Some person from Facebook.
Okay,
From
passed
there.
away. Full stop. Para. Registry is accordingly directed to issue a notice to the appellant so as to enable him to engage a new set of counsel. List after 6 weeks along with a report on such communication. So, Doctor, you're waiting for long which matter?
21.
What orders matters?
Order.
Why, what orders?
But actually, last time it was agreed upon that it will be taken up for final disposal.
But it came for orders again today, Lordship. Because it will take some time. We are,
The
both
point
the
is
parties are
otherwise,
contesting.
in my submission, the point is otherwise very short. That the appellant is
Short
trying-
point before the vacation should not be taken. Only long point should be taken.
A very short point taken by.
Short
the
point,
appellant.
not before the vacation.
I'll remain shorter, my lord.
What is the issue? If it can be disposed of without too much of a,
No, Lordship, it will take some time. I feel.
She may take some time, my lord, naturally, for the appellant.
Because I'm the appellant.
Today
Because
we-
I'm on quantum as well as on the policy. So both the
today
things.
we don't want to burden this court.
Okay, let it come.
No,
But
if
it
it's
should come for
no,
hearing,
no, no,
Lordship.
but on a serious note, if it can be disposed of without too much of a,
No, Lordship, it will take some.
what is your point?
My 2 points, Lordship.
No, no, we are not taking it right now. What is your point? Just don't open the brief.
Okay, one is on quantum, that calculations are here, and second is on the policy condition that the premium was paid for, admittedly as per the claim petition as well as the judgment, they were gratuitous passenger, the deceased was gratuitous passenger. So on that point,
How much is it? It's a death case.
Death case.
How much is the amount?
Lordship, for that again, I have opened the brief.
Roundabout.
43,38,555.
What was the deceased doing, Mr.
He was
Doctor?
a
Teacher in a school.
School.
Government school.
Going by a bus.
She was
No.
traveling in a car that dashed against the
Truck.
vehicle, truck. And resultantly, she was in the front.
And
seat.
whose vehicle was it?
No, not bike, Lordship, yeah,
Bike,
car.
she was traveling in a car.
Oh, the vehicle, I said. Whose
Maruti 800.
We said vehicle, we did not say bike. Whose vehicle was it?
The-
Whose vehicle?
I mean, the owner of the vehicle, owner of the car.
Understood. How was she connected to the owner?
She said that, I mean, the claim petition says that she was a gratuitous passenger in the car.
You said yourself.
Yes.
Okay.
The
Who's
claim
the-
petition said that she was a gratuitous passenger in the car and died as a result of the accident.
The car was not a commercial vehicle,
Not a commercial vehicle,
private vehicle.
private vehicle. Private vehicle covered by a comprehensive policy, that is known as package policy.
Understood.
So the question that the appellants are trying to assert before this court is that whether in a comprehensive car covered by comprehensive policy, a passenger like that of the claimant will be entitled to full compensation, or whether it will be limited to the extent of coverage. given in the policy. That is the only question. As far as the policy condition is concerned, and on the question of
The
quantum,
limited coverage would only have a cover for the owner driver.
yes.
That is their contention, not for any other passenger.
No, no, no. The premium for other passengers was also paid in this policy.
They want to say that it will be premium for other passengers will cover the risk to the extent of the amount mentioned in the policy, not beyond that. That is their content. And
As per your assessment, what should be the compensation
Lordship, 1 lakh was the cover. That was,
for any passenger?
no, for all the people.
Total.
250, no, if it is the person who is hit outside, that is different. Lordship. He was traveling.
That's a third party. That's a different.
third party.
Yes.
No, so
Here, Lordship, yes, 1 lakh.
1 lakh
rupees.
only.
250.
Their contention is that for
250
occupant, for an occupant other than owner driver, it will be limited to 1 lakh.
And owner driver?
Owner driver
separate
was,
coverage was there.
yes.
So
100
so it will
rupees
be
is
as
paid.
per the quantum specified in the policy. That is their content. And as regards the quantum, my lord, if the first condition, if the first submission or the first ground succeeds, then the question of quantum is irrelevant, redundant, because their liability is not coming in anyway. If the first ground fails, then their question is on the quantum. They want to say that the income was not assessed properly because the school certificate, the inspector of schools forwarded certain.
Okay. It will take some time. Let it reach first, then we'll see. They'll take up.
Fine, Lord.
May I please? Your service of notice to paper publication is done, my lord.
Okay.
And also affidavit is already filed, my lord, on dated 1/2/2021, my lord. So service is regarding service and reports, my lord, the case is ready for hearing, my lord.
You had published where?
Enclosed there, my lord, in the record, my lord.
Okay. Heard Miss L. Sharma, learned counsel for the appellant, who has drawn the attention of this court to the affidavit filed on 11/9. This has not been taken in
1/2/2021, my lord, affidavit is filed, my lord. 2021, my affidavit is filed with.
Now, why did you make a mention that you take steps by registered post in spite of the paper publication?
Someone has taken, my lord.
No, that's your
Paper
submission.
publication is already done, my lord.
No, submission is from your side, from learned counsel appearing on the. See what is the order? So and so learned counsel appearing for the appellant submits that although time was granted to take steps by registered post ED by this court in view of the paper publication made, steps were not taken by the registered post as directed.
Not necessary, my
He,
lord.
however, submits that 2 weeks further time be granted so that additionally he can also undertake. Why?
Not
why this
necessary, my lord. Yes, my lord.
If you're thinking that is not necessary, you should have told.
Other colleague, my.
You cannot blame your colleague. Submission made by a lawyer is for us is all the same. Heard Miss L. Sharma, learned counsel for the appellant to the affidavit filed on dated Kushilo, no? Date Kushilo? Affidavit filed on 11/11/2019.
13/6/19. Thereafter, my lord, affidavit, we have not filed affidavit, we filed 11/2/2021, my lord.
There is some note, my lordship.
Your filing you do not know, madam. What is this?
Yes, my lord.
You have filed this affidavit and you are denying a filing of the affidavit. We are recording as making an observation in your favor and you're stating that you have not filed affidavit.
Some colleague appeared,
What
my
is
lord.
this,
that's
your,
why-
my some colleague? Don't make this kind of submission. We have checked the records and passing the orders. How did this copy of the newspaper came to the records? Tell us. How did it come? Tell us. It came on its own. Or the newspaper company has given to the court. Who will give this?
Alert, my lord, court alert, my lord. Here. Filed affidavit, my lord. That's all.
Your manager has filed this affidavit and you are not even aware. You don't check court records. You don't have the file. This is your copy, madam. কি করলো? Along with which the copies of the Osomia Protidin and Assam Tribune dated 12/10/2019 have been enclosed. Full stop. The said two newspapers contain the notice issued in connection with the present appeal. Full stop para. In view of the aforesaid facts and circumstances, comma, the requirement of taking further steps by registered post with AD is dispensed with. Full stop. Notice is held to be complete. Full stop.
LCR receipt.
LCR has come.
Receipt, my lord.
Since the appeal was admitted, the appeal was admitted long back on 19/6/2014 and LCR has also been received. Full stop. List for admission, list for hearing immediately on the reopening of the vacation.
Obliged.
Yes, Mr. Smith.
And my lord, this is an application under section 82 PH Act, my lord, against the judgment.
Appeal.
Appeal, my lord. And by-
Yes, not yet admitted.
by document 18/1/19, it's been
Yes.
admitted.
Admitted, lordship, but LCR, because
LCR not come.
Not called. My lord, as I've gone through the request by the order dated 6/6/22, the respondent number 2 has been informed, but by
This one too has passed away.
my lord, that's what
was from earlier date, not yet informed.
Now, Mr. Kolita, you are for whom?
For respondent one.
One. If two has passed away, you need to take steps.
my lord, we're not sure whether it's passed away.
Who has to? Who is to?
My lord, who is the
Who is
chief
the,
chief terminal manager? My
He is
he-
the official of IOC.
IOC, my lord. Even one
Is he required?
my lord, one is enough, my lord.
Enough, one is enough. Okay.
He is the only witness.
Why have you made him party?
Two may be.
Part 3, M. Smith. Learned counsel for the appellant in this appeal preferred under section 82
This is under 82.
of the
Yes.
ESI Act. Full stop. The appeal was admitted on 18/1/2019 on a substantial question of law. Full stop. However, comma, records were not called for. Para, call for the records. Full stop. Sri K. Kolita. Learned Counsel is present for the respond number 1. Full stop. Para. This court has also noted that on an earlier occasion, comma, it was apprised that the respond number 2 had passed away. Full stop. Para. The respond number 2 was the chief terminal manager of the respond number 1, and since he was an witness, comma, he was made a party by name. Full stop. Para. Sri Smith, the learned counsel for the appellant, submits that the presence of the respond number 2 is not necessary, as the interest is looked after or would be protected by the respond number 1, which is already represented. Full stop. Para. Accordingly, the name of the respond number 2 is struck off. Full stop. List registry to issue requisition for the LCR and list this appeal after receipt of the same.
One more thing, Madam. On the 18/1/19, the appeal was admitted. One substantial question of law was framed.
Yes.
The other substantial question of law was not when liberty was granted. It was referred with the leave of the court.
Let the LCR come, we'll frame it.
My lord.
Oh. You have that ready, have that, you keep it ready on the next date.
My lord.
Lordship, in this case, we had filed our additional affidavit. Lordship will peruse office note dated 26/24.
Yes.
And that is in flag X, Lordship, the newspaper.
Okay.
For service of notice on respondent number 1, Lordship, because he was not
Okay.
appearing.
I heard Miss R.D. Mazumdar, learned counsel for the appellant, who by means, this is applicant.
Application, Lordship.
Applicant appellant, who by means, who by referring to the office note dated 2024, has submitted that an additional affidavit has been filed to bring on record the paper publications made in this case for service of notice. Full stop. Perused.
Flag X.
The affidavit, additional affidavit filed on 10th of June 2024, along with which a copy of the concerned newspaper, namely
Ohomia Barta
Ohomia Barta,
or Neomia Barta.
Neomia Barta, dated
21.
21/5/2024, has been enclosed, wherein the notice has been published. Full stop. Para. The said publication has been made in terms of the order dated 26/4/2024 of this court. Full stop. Service is deemed to be complete. IA is for
Delay, Lordship. Delay of 81 days. For respondent number 2, Lordship, already Wakalatnama filed. So, name is
is deemed to be complete. Well, last occasion these facts were there. Why was service not held to be complete?
Lordship, that court felt that let it come next.
Okay, service is held to be complete. Full stop. List this IA for consideration immediately after the vacation. How many days delay?
81 days.
The other advocate is who's there?
for respondent number 2. His file.
Name A Sharma.
Yes.
ठीक है, तारा गौर तो लिखिए बस. The respondent number 2 is however absent, though names of the council is reflected in the cause list. Full stop para. In the interest of justice, list immediately after the summer vacation for
Hello,
consideration. Yes.
Lordship, wrongly, I have left the file today inadvertently, and it is already responded appeared, Lordship.
Transfer matter
Transfer matter, Lordship.
of a
And
matrimonial dispute
matrimonial dispute.
from
From Guwahati to Sibsagar.
you are at Sibsagar.
Yes, dear Lord.
The dispute is of divorce.
Divorce, divorce.
You have filed a divorce petition
Yes, husband.
at Guwahati,
Guwahati.
and she wants a transfer to Sibsagar.
Yes, sir.
Okay.
What's the copy we furnished us? We have not yet.
He doesn't have the copy himself.
Oh, okay,
Okay, we serve a copy.
I'll serve, Lord.
Heard Sri A. Arshom, learned counsel for the petitioner. Also heard Sri Chandak, learned counsel, who has entered appearance for the sole respondent. Full stop para. Sri Shom is directed to, who has appeared on the sole respondent on being informed about this case. Full stop. Sri Shom, the learned counsel, is directed to serve a copy of the petition to Sri Chandak, and the matter may come up for admission immediately after the vacation. Full stop. The interim order passed earlier to continue till the next date of listing.
Oblige, Lord.
We can fix a date if you insist.
Yes, Lord.
Immediately after vacation, list on. You tell us the date of your convenience.
Lordship.
11th and 26th.
26 July, my Lord.
Yes. Okay.
Oblige, Lord.
Please, Lord.
Yes, transfer petition.
Lordship, transfer petition. Lordship, my respondent. Lordship, my husband filed dissolution of marriage at Uprasar. He is the junior division.
Now, why is it listed today? You have appeared.
Yes,
Okay. Then
I have filed the objection, madam.
you file objection.
Hmm.
Okay, we can.
Further given in the meantime, my lord, there is a talk between the parties, my lord, going to talk between the parties, my lord.
What is your petition about? What is your main suit about? Suit for divorce.
Yes, yes. Suit for divorce, my lord, only with a view to compel her to return back to matrimonial.
You don't have any provision for restitution.
Restitution, my lord.
Parties are Muslims.
Yes, sir.
So you have filed under, there is no provision for restitution of conjugal rights.
Restitution means, my lord, she is not wanted, my lord. She is
No, no,
sitting
is there
right
any
now.
provision in law to file an application or suit for restitution?
Restitution, there is a provision, my lord.
That is a
There is a
provision. Which provision?
My lord. My lord.
Under what provision? Which section? The divorce petition, divorce proceeding is instituted under what law? Hmm? Where is the plaint, Mr. Counsel?
The plaint is space 10, my
10.
Understand 309 of the Muslim Partner Law.
307.
Space 10, 11.
307. There would be some, in the application act of, in the act of 1937, there would be some provision for restitution, I think. What is this kind of submission? You want her back, so you have filed for divorce.
I don't know. Just filed it before the Kukrasar matter.
If you want her back, file restitution. By
Just
filing for
file.
divorce, can you say, no, I want her?
My lord, case may be kept pending, my lord. In the meantime, my lord, talking is going on, my lord, between the.
Is there any talk?
Yes, your lordship.
Okay, we'll grant some time. Okay,
yes.
what is your name?
Dr. Arhok.
Dr.
Arhok. Reza ul Haq.
Arhok.
Yes, Lord.
Heard Dr. Arhok, learned counsel for the petitioner. Your name is not appearing, Mr. Ahmed?
A.M. Ahmed.
No, no, it's not appearing.
Okay.
Oh, yes, yes, it's there. Also heard Sri A.M. Ahmed, learned counsel for the sole respondent. Full stop. The learned counsel has jointly submitted that there is a talk of settlement outside the court. Full stop para. In view of the aforesaid submission, list after 3 weeks.
Okay. After
3
vacation.
weeks. What about the proceedings?
That part.
Hmm?
Matter.
What is the stage now? Stage.
Yes, my Lord. My information on appearing.
You are from Sibsagar
No, Gwalpara.
and you have proceeded. Where have you instituted?
I stay at Guwahati, Lord. He is originally belongs to Gwalpara, my Lord.
Staying at?
Stay at Guwahati, Lordship. And now.
You are at Guwahati.
Yes.
And where have you instituted the suit?
My Lord, husband house is Kokrajhar.
Kokrajhar you have instituted. Is she appearing here? Is she required to appear at Kokrajhar?
Kokrajhar. Yes, Lordship.
Then we can stay it if you are.
No, my Lord, I want to transfer if the case is successful. My Lord, maybe transfer at Gwalpara, my Lord. Why she is staying at Guwahati? I don't understand, my Lordship. Already,
Mr. Ahmed, that's a subsequent consequence which we may think of on the next date.
Yes.
But right now we are giving you time because you
Yes.
have stated that there is some talk going on.
Yes.
So till to protecting the interest of both the parties, we'll just make an observation that till the next date, no proceedings will.
Case is pending, my Lord.
Huh?
Case is pending.
But she is required to appear at Kokrajhar day to day.
Yes, Lordship. Next date is 17 here. 17 July.
17 July.
For ADM.
Okay, we'll fix this on immediately on the 70 on 15th.
Yes.
15th.
Yes.
If nothing happens, then 15 you can you can press for your interim relief. Okay, that's what কি হলো? List now list is this matter is adjourned to be listed on 15th of July 2024 on which date the learned counsel for the petitioner would be at liberty to press for interim order.
Lordship, if it is fixed, then let it come for final hearing, Lordship, because service is complete, LCR is received. Otherwise, if it comes for orders, Lordship, it doesn't help both the parties.
Has it been admitted?
Yes, Lordship. Admitted, LCR has come, everything has
We'll have
happened.
it for hearing.
Yes, Lordship.
Only thing is
Where the original claim is of which year?
2017.
17.
Accident is of 17.
Let it be on 16 July,
Now,
Lordship.
have you received anything?
No, nothing. They are resisting our application for release of the deposit.
How much?
50% was deposited. 30 lakhs was deposited. They are even resisting that. That has necessitated, my Lord,
That's why, Lordship, final hearing is necessary, because we are on the policy, and Lordship, it can be on 16 July. It doesn't make much of a difference. 16 is a Tuesday, Lordship.
There is another difficulty, my Lord. If it is straightway posted for hearing, they have filed an application for.
Adducing fresh evidence.
Yes. Whereas, my Lord, that application is yet to be decided. Now, if the matter in this stage goes to the hearing, my Lord, then it will be a difficulty.
No.
And in the application also, my Lord, it was listed only in the last day. In the application also, my Lord, no ground has been.
That
made
is under
for-
4127.
Yes. And no ground has been made.
Why?
As per here.
No, we have.
Why it should be decided?
What
now?
additional evidence, madam?
It is mentioned, Lordship, that para 8, that neither the policy is in dispute in the present case nor the terms of policy. Policy is not in dispute in this case, Lordship. But still, the applicant is desirous of exhibiting the policy so that this honorable court can be held in proper adjudication of the case. Does that, Lordship? They are not.
May not be necessary.
Yes, Not necessary, because we have annexed that
Now,
with our appeal also.
4127, my lord, knows, my lord. There are certain circumstances where only, my lord, the.
No,
can be
Mr.
permitted.
Datta, you know the limitations in 4127. It's not a routine manner that you file 4127. It's only an exceptional thing.
Yes.
In fact, it's a bar actually.
Actually,
And
it's
there is a limitation that while applying the bar, only on few circumstances you can allow. We will say it's a bar, and if what Madam has said that there may not be a dispute with regard to the policy. So that may not
No,
be.
my lord, why they want to bring it now, my lord? The reason is that the kind of defense that they are urging in the appeal, kind of attack they are trying to, there is no whisper of this kind of defense even at the cross-examination. So I have checked the cross-examination of the witnesses, my lord. No whisper even on quantum, no whisper even on the.
In the WS? In the WS? What about the WS?
Nothing. In the WS also, there is no statement that because of this, the policy is not covered. I mean, the risk is not covered and the compensation is not payable.
There are 14, 15, 19.
These are all general
I'll
statements,
go
my
into
lord.
the,
Now, just to cover up that, my lord, this application.
Okay,
has been
16th.
moved. My lord, 16th, I'll have some.
18th?
Yes, 18th.
18th. Okay. Do in terms of the interim order, 50% of the award has been deposited by the appellant insurance company, the prayer for release has been resisted on the ground that the policy in question would not cover, and therefore the award is not sustainable, full stop. The aforesaid proposition is, however, vehemently disputed by Sri S. Dr. Dhananjay Senior Counsel for the claimant, full stop, para. Considering the aforesaid aspect, list this, considering the aforesaid aspect, and also noting the fact that the LCR has been received, list this appeal for hearing on 18/7/2024, full stop. On the said date, this court may also consider IA 1752 of 2024 filed under Order 41 Rule 27 CPC. Okay.
I'll oblige us.
Yes, please.
This is an application for continuation of delay in finding.
First
appeal.
time.
First time.
How many days?
105 days.
Here for announcement.
Plus it.
Okay. Part 3, M. Taluta Learned Counsel for the applicant who has filed this application under Section 5 of the Limitation Act for file this application under proviso to Section 173 of the Motor Vehicles Act, read with Section 5 of the Limitation Act for condonation of delay of 105 days in preferring the appeal. Full stop. The concerned judgment and order is dated so and so, passed by so and so, in so and so, and the applicant is aggrieved by the adequacy of the award. Full stop, para. Let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps within 2 days.
Also by usual process.
Let it be registered. This is IA only. Let IA be, otherwise it will remain like this.
Okay.
Make this is a lordship. Lordship that day, lordship heard this matter. That it is, and then lordship directed the New India Insurance to appear.
Oh, yes, yes, yes.
The deceased was himself owner and he was driving the vehicle, and my contention was that the law permits that only what is covered by the policy, 2 lakh of rupees, that is to be.
No, we'll have to be, we have to recapitulate the facts. Mr. Otherwise, any instructions by you?
No, Lordship, I just got kind of only when that my name was not shown in the cause list today.
You get
sir.
some instructions. We'll like to hear this matter properly. It's a very important question, not only involving this accident, anywhere. It's a very dicey kind of a situation. Anyone may meet with such an accident and get nothing. Though she may be correct in contending that the contract of insurance is only to indemnify when there is a claim by any third party upon it. And if the owner is the victim, what will happen? Okay. You have otherwise appeared officially?
I'm officially, I filed a condemnation, only that my name is not
Okay.
considered.
Okay. In terms of the order passed on the last occasion on 18/6/2024, comma, Sri R. Goswami Learned Council has entered appearance, namely the New India,
Respondent number 5.
New India Assurance Company Limited, by filing wakalatnama, full stop. However, comma, his name has not been reflected in the cause list. Para. List immediately after the vacations by reflecting the name of Sri R. Goswami.
Let me give a date so that.
It's a 12 matter, it'll come early. R. Goswami has learned counsel for respondent number 5 in the cause list.
Early obliged.
Cause list दो बार लिखा क्या? नहीं ना? हाँ, ठीक है. Yes.
Well, here I have highlighted brief written submission. My learned friend also has filed brief written. Today I have received the copy. My lord, matter. The private case, my lord, here the DC Pulawala Tap, my lord, executed a private,
Will.
on a 1st July 2012 night. After 4 days, he died. Only the year, my lord, the suspicious circumstances, the date of execution of the will and her date of death is very close. That is why suspicious circumstances arose in respect of their will, my lord. Here, your lordship will may also see the will. In the will, why she executed the will, that has been very nicely explained. She has explained. Now your lordship will see the judgment that has been passed by the learned district judge. Additional district judge Barpeta. Lordship will see the judgment. That's why your lordship will see the judgment. Here I examine, my lord, 5 petitioner side. Examine the 5 witnesses, my lord, and the respondent opposite party side. Examine the 2 witnesses.
What are your grounds of challenge here?
My lord, here I have written, your lordship will see my written. Very 3 grounds I have taken. Lordship. The first, my lord, your lordship will see the issue. Issue, my lord, the issue is whether the deceased Teshwar Pulwala Das during the lifetime on 1/7/2012 executed the one will in favor of the petitioner of the case. Whether the will was executed with undue influence of the petitioner by the deceased Teshwar Pulwala Das, whether at the time of execution of the will, deceased Pulwala Das was not in a sound health and mind, whether the petitioner.
Who are you?
I'm the, in my favor, the will was executed beneficiary.
Okay. You,
The founder of the. We filed for issuance of letter of administration. No executor was appointed in the will, that is why we filed for grant of letter of administration.
this probate case was dismissed
Yes, probate case was dismissed. That I have. we
on
have
the
filed.
objection filed by the other side.
Yes, objection.
How are you
Yeah,
connected to
is it
the,
a content case? Content
and how, this was converted to a suit?
converted to suit.
Okay,
Converted.
and how are you connected to the testator?
My lord,
Are you related to the testator?
yes, my mother-in-law. Daughter, the will was executed in favor of daughter-in-law and two granddaughter. And they are also, my lord.
You're the
daughter-
daughter-in-law
Yes, daughter-in-law.
of the testator.
Yes,
And Mr. Iqbal,
daughter-in-law. She is
I'm one
also-
of the sons.
you had contested.
I-
One of the other sons.
Objector is also
So I'm
daughter-in-law.
living to the son.
Hmm?
I'm the wife and daughter of the one of the.
Yes.
You're a granddaughter.
Daughter.
Daughter-in-law.
Daughter.
Another daughter-in-law has.
Daughter is fighting between two daughter-in-law. Yes, my lord, why will was executed?
Why it was not
our
given
favor?
given to the sons?
My lord.
Sons were not predeceased or what?
No, one of the son
One.
predeceased, but the other son, that is he was alive.
No, at that time. Later died.
And what are your grounds of objection?
Objection, my lord, she was not keeping well. She was a heart patient, my lord, from the date post 6/2012 till 27/6/2012, my lord, she was in the hospital. And on 28, my lord, she was discharged. The will was executed on
1/7.
1/7.
She was
Thereafter,
discharged when?
27/6/2012.
While she was in the hospital, that means.
After she
Once
was,
1/7, she has to be in the hospital.
she was, no, my lord, she was discharged on 27/6/2012.
27/6, okay,
27.
immediately after the discharge.
Immediately after, because she was discharged from the hospital, because there was no, the doctors told that, my lord, there is no hope. They have to go back to home.
Okay, no, then,
Absolutely
Then,
purpose.
my
no,
lord,
then,
Yeah.
Then, my lord, the will was executed, stamp papers were bought on the 28/6/2012. Will was executed on 1/7/2012. Thereafter, again, she was hospitalized and she expired on 5/7/2012. So the learned trial court held that, my lord, if a person is counting her days, then there is absolutely no question of, my lord, executing a will in sound health and mind.
she used to give her signature by thumb.
No signature.
It's written.
Signature.
Ticket.
Not like a movie after the death.
No, not like that.
Absolutely purpose. No documents to show that she was seriously ill. Then in that event.
But she died after 4 days of
Yes,
executing
it
the
is a
will.
fact. It is a fact, but suddenly she died. Suddenly.
You don't have any role
No.
to
My lord,
expedite her death.
Your lordship, first my ground of challenging me. First ground, my lord, I have here your lordship will see
But
the
don't you find that circumstances are very suspicious?
no, I agree. I already made
26,
submission
she
that
comes-
within a very proximate, very close.
No, she was in
date
the
of-
hospital.
Date of my lord.
We are
execution of
not
will
only
and
on the-
that is a very
We are not
close
on the date of death. We are on the date that from 27/6, she is discharged from the
But
hospital.
What was her disease? Skin disease. Not a serious disease.
My lord, for
They
a
will
skin
produce,
disease,
let them
nobody will
produce.
keep a
They-
patient.
Now,
they
how
have
did she
exhibit
die?
one, Exhibit B, which clearly shows that she has some skin disease.
Okay, how did she die?
She died, my lord, she had a, earlier, my lord, she had some heart problem. It is a fact. In the
No,
will
that-
itself,
that-
in the,
that-
that has not been suppressed. In the will itself, it is written, but she was not on any under treatment of the heart disease. She was under treatment of skin disease,
For how many
They
days
have-
how many days in the hospital?
my lord.
How many days for skin disease in the hospital?
No,
24 days.
your lordship will see that documents also. She was under the treatment of skin disease. Skin disease. They have produced that exhibit B, your lordship will see.
24 days in the hospital.
Not 24 days.
How many days?
Lord, there is no document. I think
The period is not disputed.
you have submitted the document, no? What document says?
Tell us how many days according to you?
Few days, my lord, few days. Okay. Okay. Exhibit B, my lord, they have exhibited.
Will also says that she was suffering from heart disease.
Yes. Heart disease, but we are not under treatment
Hmm?
for heart disease. We are under treatment for skin disease.
Where is the document?
That is exhibit B, my lord.
Exhibit B.
Exhibit.
LCR আছে নি? हाँ, exhibit B कौन?
Exhibit B states that by the skin disease,
Skin disease.
but by the
अच्छा. हाँ. Record to some. Exhibitor file 2. What is DCMP means? What does DCMP means? It's a medical term, just check.
DCM means, my lord, dilated cardiomyopathy.
Mr. DCMP is also there. It's not only skin disease.
Enigmatic cardiovascular disease.
Yes, DCM is, I know that's it's something essentially to do with the heart, DCMP.
Chronic.
We know this expression.
Yeah.
Lanoxin is essentially a heart ailment medicine, Lanoxin.
But no, they are not serious, man.
Ramesh, all are, these are,
She was in a position to understand everything, but she put her signature.
but see, to ascertain the veracity of a will, we employ the standards of a reasonable person.
Yes.
Whether the execution prima facie appears to be in a condition where the executor was on sound health, both physically and mentally. Here,
in a sound state of mind, she was in sound state of mind. The attesting witness have also stated. Sound. We have proved that.
who is the attesting witness?
3 and 4 and
Who are
5 is the scribe. The last time I have given the translation.
Who are the attesting witnesses? Any idea?
Yes, your lordship will see my translated English.
Yes.
English. But in the he Utpaljit Das.
Who is he?
He is a attesting witness, man.
How is he connected? We know he's there.
Connected. Yes, yes.
What did he say?
He said, in chief, he said, this is Pulawala Das was known to me, who expired on resident at village. He said, my lord, I am a permanent resident of Katapopo. This is Pulawala Das was known to me, who expired on 5/7/2012 at her one resident at village Karatala under PS district Barpeta. It is true and correct to the best of my knowledge. The deceased Pulawala Das wished to execute a will in favor of the petitioner, and she requested me to present her resident on 1/7/2012, and I positively attended her residence within the time of at 10 a.m. at the time of execution of the will as a witness of the said will. It is so when I attended the residence of the deceased Pulawala Das at about 10 a.m. on 1/7/12, on advocate, namely Thakur Medhi, was also present to write the will along with Sanjit Das and Manmohan Udir, who already expired, were also present at her residence at the time of execution of the will. As per direction of the deceased Pulawala Das, Thakur Medhi, advocate, written the will in the presence of me along with the other witnesses, namely Sanjit Das and Manmohan Udir, and after writing the will, Thakur Medhi, advocate, read over the same to the deceased
Pulawala Das, and this is Pulawala Das execute the said will on 1/7/2012. It is true and correct to the best of my knowledge and belief. At the time of execution of will on 1/7/2012, this is Pulawala Das was under sound mind and she executed the same with her own consent and without anybody undue influence. It is true and correct to the best of my knowledge and belief. Exhibit 1 is the will executed by this is Pulawala Das on 1/7/2012, and exhibit 110 is my signature as a witness of the said will executed on 1/7/2012. True and correct to the best of my knowledge and belief. This affidavit shall be used as and you are a cross-examined. And cross-examination, your class. English, sir. Pulawala, in cross-examination, he said, Utpal Lita said, Pulawala Das had called me to be witness in the will. At the time, she was completely healthy. She was able to walk and roam around. Deceased told me about making of will in advance. Pulawala Das had to be taken to the hospital before she died. At the time, she was physically weak. I put my signature at the end of Exhibit 1. I cannot say who first signed the Exhibit 1. I cannot say who brought the stamp paper. I do not know about the civil case relating to the hand of the will. Pulawala Das was healthy at the time of executing the will. After executing the will, she was taken to the hospital. After 4 days of taking the hospital, Pulawala Das died. This is signed in front of me. Thakur Das has shown to Pulawala Das where to put her signature. Daughter-in-law of Pulawala Das gave pain in the hand of Pulawala Das. It's the first part. Another attesting witness is PW4, Sanjit Das. Here also such a similar stated to and PW5 is the scribeman. He wrote the will. He's an advocate.
Who is Nirmal Uzir? Your client? Nirmal Uzir?
Nirmal Uzir, not like that.
Nirmal. Read. PW2. PW2.
Who is he?
He said nothing. PW2.
DW2. Your witness.
He said nothing.
No, he has said it's not possible to.
No. Here, Lordship will see the cross part. Cross part.
Cross parts?
Cross part.
You will not read the cross alone.
My lord.
He said clearly that is.
No. What he said.
You will not read the cross. Read the cross.
Babul Das is my sister in relation. I have got good relation with them. She lives at Istapuri. My house is at Istapuri. For Sala is a different place. I stay outside. in the day in connection with the service. I do not visit the residence of mother-in-law Guru Das always. I do not know their family matters. I have not seen the execution of will, but Guru Das told me about the execution of the will and the litigation. I do not know about the land of Guru Das. Guru Das asked me to give the evidence and I gave evidence.
Yes.
I cannot say what is written in para was in my evidence on affidavit. I cannot say what is written in parawise in my evidence on affidavit. I put my signature in the affidavit as asked by advocate. I have absolutely no any knowledge. I have absolutely no any knowledge. In the first example, I do not know about the death of the deceased, but I know that she was released by the doctor from the hospital. It is not a fact that I gave the false evidence against the plaintiff. Not reliable, not credible.
Have you seen the signatures in the will?
Yes.
She's not even able to scribe, put the pen.
That also goes to show that she was very weak.
Not very weak, but her handwriting is like that.
No, it's not handwriting. We can infer something, Mr. Upadhyay. Just see is this a signature?
She used to like that. Almost illiterate lady.
That was admitted by the PW4 also in the cross exam, that she was very
weak. Well, she was allowed. She was in sound state of mind. But here, my lord, the honorable district here, it is district my lord, the issue was same like this. Whether at the time of execution will disease products were not in sound health. The sound health is not requirement. Only sound mind. Section 59 of the Indian Succession Act says that the sound state of mind, not the sound health. So the issue are also mind of not correctly framed. Issue number 3. And other issues are not at all decided, except the issue number 3, other issues are not at all decided, not discussed, not decided.
We'll consider this after the vacation. I think there are something to be seen.
pilot. If pilot has gone through all the evidences, there is absolute non-compliance of section 63C subclause. None of the witnesses, pilot, has stated that they have put the signature in front of the testator. That is in fact not there in the pleaded case also, not in the evidence. Then there is again non-compliance of section 281 of the Indian Succession Act.
No, but see, Utpaljit, we are reading Utpaljit Das is one of the witness in the will. So-called witness. Let us, we're just reading that part only. It's there. Paragraph 4 and 5, Utpaljit. That as per direction of the deceased Fulobala Das, Thakur Medhi advocate written the will in presence of me, along with other witness Sanjeet Manmohan, and after writing the will, Thakur Medhi read over the same to the deceased. Deceased executed the will on so and so.
May I just read section?
Section?
63,
Please read.
The will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has been some other person sign the will in presence and by the direction of the testator, or has received from the testator a personal acknowledgement of his signature or mark, or of the signature of such other person, and each of the witnesses shall sign the will in the presence of the testator, but it shall not be necessary that more than one witness be present at the same time. So, my lord, each of the witnesses has to put the signature in front of the testator. So that part is the same.
No, he has said.
Well, he has said that, my lord, Thakur, the advocate, was present.
Yes, no, he was also present.
He was also present, my lord,
No.
but he has put the signature in front of the testator. That is. That is.
No, the emphasis should be that the testator has signed in his presence.
Right.
Whether the witness has signed in the testator's presence, that becomes a secondary part. The importance is the paramount importance is of the signature or the mark of the testator. Whether it was done in the presence of the witness or not, or whether it was a forced one. He has given his witness evidence that it was done in my presence.
But in the cross part, again, he has stated that, my lord, I cannot say who first signed the exhibit one. If he was present, my lord, at least he could have recollected that who has put the signature. That also he could have said. Same was stated by the PW4 also.
Okay, we'll consider after revocation.
Fine.
This week. Okay. Why is it nomenclatured as interstate case?
Ought to have been testament.
No, interstate case. Why case? It's not an appeal.
It ought to have been appealed.
So why is it?
But it's cut and then it is taken.
No. Why is it nomenclatured as case? I would not know. It's an appeal under 299.
It is appeal, my lord.
No, nomenclature. It's called interstate case.
I don't know.
This appeal filed
Intestine
under
case,
section
intestine case, my lord.
intestate, not intestine.
Intestate case.
This appeal referred under section 299 of the Indian Succession Act is of the year 2017, wherein LCR has been received. Full stop. Para. List for hearing. On the reopening of the summer vacation. After on reopening.
Vacation?
After
Yes,
vacation.
after vacation.
Finish date.
Date we are not doing. It's an old case. It will come. Don't worry.
26. Deeply open.
Yes.
Lordship, in this matter, conducting counsel, Mr. S.P. Chaudhary is in court number 26. Can it be
What is
taken?
your appeal?
Yes, Lord.
What are your grounds?
Lordship, disability is assessed, but without examination of doctor, Lord.
Okay, we'll have it after the vacation. A prayer, those three ages I can counsel for the appellant is present, comma. A prayer for adjournment has been made on behalf of Sri S.P. Chaudhary, London Council for the claimant. So, para, placed immediately after the summer vacations. Okay. Hearing or put over, hearing, no, 27, yes. Yes, madam.
My lord, other side can start.
Other side, it's your appeal.
Yes, my lord.
How will the other side start?
Actually, this matter is prepared by Siddhant.
We'll have it after the vacation. Okay. A prayer for adjournment has been made on behalf of the appellant. List after the vacation. List for hearing after the vacation, yes. Yes.
In this case, substantial question of law involved in this case, Lordship.
The hearing matter, hearing will have after the vacation. Okay. After the vacation, was there a delay condonation application?
No, I'm appeal. Lordship.
It matter looks old, but it's 23 matter.
Yes, sir. There was,
No, there was delay condonation. Yes, it was 14 matter. Okay. What are the issue involved?
Whether the learned commissioner was justified to consider the wage of the deceased workman at ₹6,000 per month, or to compute the compensation accordingly, in as much as per court notification which was in force at the time of the accident. This statutory ceiling for any workman was ₹4,000 per month.
Yeah, what do you say?
My lord, in this case, my lord, the income of the victim, my lord, he was used to draw, my lord, 6,000 salary, and his income was, my lord, the PW1.
Did you prove the income?
No, my lord, but the statement is there. PW1 and PW2, my lord, constantly stated that 6,000.
Any document?
No, my lord, because it's an unorganized, my lord.
No, then you have to take the ceiling which is there.
Whether the amendment is prospective or retrospective, that is the main issue in this case.
And my lord, the accident took place in 2009, and the case decided on, my lord, in 2014, my lord. So, my lord, in this case, my lord, the 6,000 salary, my lord, my lord, there is no infirmity in the husband, my lord. Because it's an unorganized, he was employed as an unorganized institution. Unorganized institution normally, my lord, do not issue, my lord.
Unorganized institution means what?
My lord, the owner of the vehicle, my lord, he was employed under the, my lord, owner of the offending vehicle, my lord. So, my lord, normally the owner of the vehicle, my lord, do not issue, my lord, the income certificate, my lord. So, my lord, is like an unorganized institution. So, my lord, it is difficult for the, my lord, petitioner to prove, my lord.
Was the income taken on an exceptionally lower side?
In this case, accident took place on 10/9/2009, and the amendment was come into force, Lordship, 18/1/2010. After amendment, the maximum ceiling was 8,000. At the relevant time of accident, it was 4,000.
And how much has the tribunal taken?
6,000.
6,000. It should be 4,000.
4,000. This is the effect for this one.
Okay, we'll have it after the vacation. Okay. List for hearing immediately after the summer vacations.
Can it be a date matter?
It's a old matter. We'll have it. Don't worry.
Highly obliged, your lordship.
What is this review about, Mr. Chakraborty?
Okay, review of an order which one first M. Bora has been appointed as the arbitrator, because we did not receive, though we CGC represented, but the concerning authority has not received any notice. In view of that result, she was appearing in two cases against us. And one is against the same division, lordship, as a counsel. the arbitrator. We filed a petition before around for declaration CS
Which order are you seeking
Lordship.
review?
page 10, Lordship. Though I appear in this case, let's say there is neither objection nor consent. So it is not known to me that she was. In fact, Lordship, page 10
Page 10.
is the order. Lordship, in fact, in this case, late Colonel Manoranjan Goswami was the arbitrator, and she was the secretary of that arbitral tribunal. And she has also passed an award against us, Lordship, for a work value of 25 lakhs, 27
No,
lakhs.
that's in a different matter.
Lordship,
That is in a different matter.
different matter, but
But did this particular arbitrator had acted as a counsel for the
Yes,
present
Lord.
claimant?
yes, Lordship,
Never,
For the
Lordship.
present claimant?
Lordship,
For the present claimant?
not present payment, but
Then-
against us.
Doesn't matter. If one court passes an order against you, will you say, no, 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 this court cannot take up matters?
That's true, Lordship.
Then,
But in case of
see,
arbitrator, that's-
the perception of bias has to be on some
Lordship,
substantial grounds.
and Lordship,
If, of course, if the learned arbitrator was the counsel of one of the parties,
Lordship,
then yes. She was not the counsel of one
she
of
is
the,
appearing against us, Lordship,
as what?
as a counsel for the other side,
Union of India, Council of Union of India, not mine,
against Union of India,
Doesn't
against the
matter.
same division, against which the arbitration proceeding is going on. Lordship.
Is it the same arbitration?
No, in a different case, Lord.
Don't find too much of a,
And she passed an award in Lordship, in which the work value was 27 lakhs, she passed an award of 1.3 crore.
that is after 35 years past the award, Lordship. On inflation, they have awarded. That too in a different context.
but Mr. Chakraborty, you had consented.
Lordship, not consent, Lord, in the sense because the Lordship, the authority, that is the works, Commander Works, Air Force, it is
No, at paragraph 3 of the order,
Lordship.
Sri So-and-so has fairly submitted that he has no objection if a new arbitrator is
Lordship,
appointed.
that is, but no notice were received by the this authority, Lordship, was looking after the
Regarding?
arbitration proceeding, Lordship.
No, no, it was already going on before late Goswami, who had
Goswami.
passed away.
Because Lordship, as per the terms of condition of the GCC,
What is the stage of the proceeding now?
no, she will start from fresh, Lordship.
Now, what is the stage now?
Lordship, I'll say, the state of, both the parties have submitted their claim. They've submitted their pleading in defense, they raised under. One hearing is held, only 2 hearings is left for giving award. It is in advanced stage, Lordship.
No, till what stage late Goswami had reached?
No, only the earlier claim petition has been submitted before us, not a fresh.
No, no. Till what stage the earlier arbitrator, Goswami, had reached in the arbitral proceedings?
I'll
That
submit,
instruction, that
Lordship.
instruction I have done. On what aspect?
And
Let
from
me
what,
submit.
what date the new arbitrator had taken up the proceedings?
That I have to take instruction,
You take instructions,
Lordship.
take instructions.
One of the condition of
Lordship.
arbitration, Lordship, was that it should be engineering grade. Arbitrators should be from engineering background.
No, it is not there. Supreme Court decision is there. When they fail to appoint arbitrator, engineer officer, then the court can appoint an independent arbitrator. It is lot of decisions are there. Which gets also given that one.
I heard Sri B. Chakraborty, Learned Council, Learned CGC. Also heard Sri G.D. Dhiman,
Lordship.
appearing, the respondent in person, put stop on the request of the parties, matter is adjourned to enable obtaining of instructions with regard to the stage of arbitration which the earlier arbitrator had reached, and from which date, and from what stage the new arbitrator whose appointment is the subject matter of this review had taken up the proceedings.
Sir, it is too late. I request to submit something. Earlier arbitrator, Colonel Goswami, he fell in ill. Then he has given a letter to the registrar. I am not going to do
At
arbitration.
what stage?
In a stage when we have the court appointed the arbitrator. After
First-
that time,
first-
yes, sir.
Before even the filing of the pleadings?
Before filing of the pleadings, I think, or may not be. That I will see. I think, sir.
Only therefore, only for that purpose we are giving you time.
We filed the pleading before the arbitrator, Colonel Goswami. Then he went to Bombay and said, I'm unable to, I'm hospitalized, I will not do. Please retire me as a arbitratorship. You appoint another arbitrator. Then Honorable Court has appointed the new arbitrator. That's all, sir. He's complete gone.
And what was the stage where the new arbitrator had reached?
News arbitrator has already statement of case, both the parties submitted, pleading and defense submitted, rejoinder submitted. One hearing has been
Lordship,
done,
let
only
me
one
take
or
a
two
second.
hearing. It is in advanced stage of giving the award, Lordship.
Without instruction, I cannot.
Since
submit.
8 months, it is the injection.
No,
has-
Mr. Chakraborty, if you are actually aggrieved and had reasons to be aggrieved, you should have come immediately.
Immediately, Lordship.
One submission.
What
was filed,
he is, what
Lordship.
is saying that 8 months have gone and it's in the advanced stage of hearing.
No, Lordship.
It is, Lordship, they have no claim. No money they are claiming on me. They have recovered many amount from me in the final bill.
Okay, you take the instruction. We are fixing a date. We're fixing immediately on the reopening
Lordship.
because he has some urgency.
Lordship.
Lordship.
List on, we'll have it on 17 July.
Lordship.
Lordship, may it be fixed in this court only, Lordship.
No.
And
This is-
Lordship, everything we.
There is a roster.
So
It comes as a roster.
kindly half hearing, kindly mention half heard of this matter.
Where have we heard?
It
It's a-
is
It's a
one kind of
roster
heard
and
also.
it's not assigned to this bench. It's not a review of this court's order.
Okay. Any fixed date, my kindly.
Yes, 17th.
17.
17th.
Oblige, Lordship.
This you can take it back. This is one copy.